Apologize for us being a little late, but we just had a few things we needed to straighten out. I'm going to call the House Judiciary Committee to order, and first I'd ask you to please join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. All right. I'm going to now open the hearing on House Bill 584 FN relative to public health, safety, and state sovereignty. And I recognize the prime sponsor, Representative Grange.
Thank you, Mr. Chair and members of the committee. Globalism is an ideology that seeks global governance, and if you think about it, that's just a fancy way of saying try to take over the world. The point of this bill is to make it very difficult for anti-American saboteurs within government to violate their oaths and duties and try to enforce the will of international organizations, thus undermining our sovereignty. I have an amendment to fix some small language issues with the original bill. That is 683H. You should have it in front of you, and I'm willing to answer any questions if you have any.
Wait a minute, hang on. What is the amendment number?
683H. And if you look at line 12, that's where the changes in the amendment are.
6838. Okay. Yep. Let me take a look at that. I'm sorry. You said it's on line 12.
Correct.
Let's see. Okay. Hang on. 12. All claims against. So you know what? Yeah, you know what? I'm sorry. I think that what begins on line 8 of the amendment is meant to correspond with what begins on line 20 of the original bill, and I think there it does make sense.
Correct.
All right. So hang on just one second. Let's take a.
Mr. Chair?
Hang on one second. Yes, I'm sorry.
So, obviously I'm a sub, and I've usually been given a notebook of all of the bills. I don't have that, and I don't have the bills.
Yep, we have. I mean, there are. Yeah. Could I just add, Mr. Grant, if you.
There's a binder there.
I'd like the binder that I had last time, if I could.
Representative Morgan? 46 to you.
Binder there, if you could just.
Oh, yeah, there it is.
Yeah, if you could just pass that down.
Thank you, Mr. Chair.
And
I
could.
The exec bills in that though?
Yes,
that
I didn't know
may
what
be
you're
the bill.
talking about.
Bill for exec session?
Which wouldn't know, but that would include these two bills. It does include these two bills.
I'm sorry.
I guess I can ask a question. If you want to recognize me, the sponsor already ended his testimony. I could ask him a question about the amendment. But
Can I? Well, I'm sorry. Have I recognized?
No, I was just
Oh.
asking you to pass the binder down.
Right. So, Representative Granger, I wonder, could you just tell us what the language change is specifically?
So on line 24 of the original bill, it says who create and enforce policies which rely on the claims of the World Health Organization. The amendment changes that who enforces policies, mandates, orders, requirements, edicts, or directives of the World Health Organization. And the intent of the bill was never to create any sort of thought crime. And that's why I thought it was important to make this small change.
Okay. All right. Okay. All right, and am I correct that Roman numeral 2 of your amendment that begins on line 14 of the amendment, that doesn't change from what's on line 26 of the original bill? Is that correct?
It's not supposed to, and it doesn't appear to, no.
Okay. No, that's what I thought, but I just want to make sure. All right. All right. Great. Thank you. Does people have questions for this witness? Representative Horgan.
Just to summarize, so the amendment, on the one hand, it takes out the create, so you don't have thought crimes. On the other hand, I guess it also, you apparently felt there was a omission because the original bill only covered policies, and this also covers mandates, orders, requirements, edicts, and directives. Is that correct?
So if you look at the first page of the bill, it says no rule, regulation, fee, tax, policy, or mandate. Line 3, no rule, regulation, fee, tax, policy, or mandate of any kind of the World Health Organization, United Nations, and World Economic Forum shall be enforced. So
Yeah.
If it would be better with the same exact language, that would
Yeah,
be
fair
amenable
enough.
to me.
In case somebody's trying to create or enforce something that's not necessarily a policy, but is still a mandate, order, requirement, edict, or directive. So I get it. Thanks. Okay.
All right. Any other questions for this witness? Seeing none, thank you very much, Representative.
Thank you.
Next, I'm going to call on, oh boy, Kaylin Farrar? I'm sorry, I just can't read the last name. I apologize. Hi.
Could you press the button?
Yeah, you know, could I just ask you to spell your last name, please?
Sure. It's Ferrier.
Thank you.
You're welcome. This morning, I'm speaking, I would like to share testimony on behalf of a colleague who is not able to be here today. But for the record, I would just like to share that I have been a nurse for 36 years, primarily in the state of New Hampshire, and I am currently the executive director of the New Hampshire Nurses Association. The testimony I would like to share is on behalf of a board member of the New Hampshire Nurses Association. My name is Laura Dolph. I am honored to be a registered nurse for 35 years in New Hampshire, acquiring my education at community and state institutions, including the New Hampshire Technical Institute, University of New Hampshire, and currently Riviera University. I am a member of several professional affiliations, including the American Association of Critical Care Nurses, the American Nurses Association, and the New Hampshire Nurses Association, and many others. I rely heavily on a variety of diverse sources of information to optimally provide care for the diverse patient populations, of which there are many residing in our beautiful state. We are incredibly fortunate to have the cultural and social diversity in New Hampshire that makes us stronger and more capable than if we were all the same. The profession of nursing has an honored place as the most trusted profession for the 23rd year in a row, according to a respective Gallup poll. Trust is something that is severely lacking in our society, and I'm here to assure you that when you seek care for an illness or other healthcare concerns, your nurse will be there for you, walking alongside you, making sure you are safe and well cared for. You will be able to trust that nurse. He or she must be knowledgeable and equipped with the highest quality information from respected resources. I fear HB 584 will place nurses in a dire position in the future as they work to care for patients in New Hampshire. HB 584 is a piece of legislation that will limit information from sources that inform my practice and optimize the care I provide, as well as the care provided by my nursing colleagues. As a professional nurse who reviews the literature daily, I can recognize its strengths and limitations, and with this clarity, I am able to support patients' choices to achieve their goals for health. It is crucial to have access to organizations whose mission is to improve the lives of people around the globe. I am imploring you to vote ITL on this bill. A responsible citizen does not avoid information. A responsible citizen learns from information. Our state has always been able to think and act independent of the current political winds of the day. I hope you will stand courageous in defense of freedom of information and our democracy. In closing, I would like to thank you for your service to our state and our people. We must start to rebuild trust, and by courageously creating and supporting legislation that is written with the best intentions, you can move us in the right direction. We must start somewhere. Thank you.
All right, thank you. Questions for this witness?
Can she submit her statement?
Yes, would you mind submitting that?
Of course.
If you could just bring it up, that would be great. Thank you very much.
Thank you.
Thank you. All right. All right, seeing no questions, thank you, ma'am. I'm next going to call on Melissa Blasek, please.
Thank you, Mr. Chair, members of the committee. I am Melissa Blasek. I am here representing Rebuild NH. Thank you for the opportunity to speak today in support of HB 584, which I have come to refer to as the Anti-Globalist Act. This bill is a crucial step in protecting the sovereignty of New Hampshire and the ability of our state to make decisions free from external mandates that could come from an organization like the World Health Organization, the United Nations, or the World Economic Forum. The essence of this bill is simple. It prohibits the state and its political subdivisions from enforcing any mandate from these entities. When a version of this bill was introduced last year, there was some concern about it being overly broad or restrictive, but I want to clarify that we are not trying to restrict the ability of the state to reference research or guidance from these organizations when making informed decisions. What we are doing is ensuring that New Hampshire is not forced into adopting mandates that could come from organizations that are not accountable to our citizens. It's important to note that the scope of the bill has been expanded from last year to include not just the WHO, but also the UN, the WEF, ensuring broader protections for our state's independence. The most pressing example of potential mandates from international influences in recent years has been the WHO's proposed amendments to the pandemic treaty. While the threat of those amendments may seem distant, we cannot ignore the fact that there could be potential reversals in federal policy after the next election. The actions of President Trump in withdrawing from the WHO were a step in the right direction, and I fully support that move. However, we must ensure that these protections are permanent. That is why HB 584 is so important. It provides long-term safeguards against potential overreach and ensures that New Hampshire's future will not be dictated by the political whims of national or global organizations. The beauty of federalism is that states have the power to make decisions for themselves. We should not have to rely on nor be subject to the shifting political currents of national or international bodies. Now, before there is an immediate threat, we have the opportunity to act and protect our rights. This bill is not just a reactionary measure, it is proactive, and it ensures that we as a state will not be forced to follow mandates we do not agree with. I urge you to support HB 584 and make New Hampshire a leader in protecting state sovereignty and individual freedom. Thank you.
Thank you. Questions for this witness?
Yes.
Representative Birch, excuse me.
Without going into the contents of any mandate, could you, for example, just tell us for the past 5 years, how many mandates from the United Nations that the state of New Hampshire has imposed on its citizens? Just numbers for the last 5 years.
Thank you. None. Again, this is a preemptive bill. It's not reactive.
Thank you.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Robert Lawleys. I hope I've got that right.
Good morning. I took a look online and saw what was coming up for legislation today and made a kind of last minute decision to stop by after I read what was going on here.
I'm sorry, could I just get a little closer to the mic?
Sorry about that.
Thank you.
After seeing what was happening legislatively today, I thought I'd come down after reading this bill. I just have a couple of questions. I know you guys can't answer it, so I guess they're going to be rhetorical. First, actually, I'd like to thank the first person that spoke. That was a really well-written opposition to this bill, which my first question is, what's the actual point of this bill? To me, it sounds like a bunch of free state I got to have my sovereignty nonsense that's actually going to do nothing, as we just discovered from the representative's last question. Number two, how about doing some bills that actually address problems that we as our citizens have, not things that have never happened. We have housing problems, property taxes, equal education for poor kids in school systems that aren't getting the funding to educate them as they should be. Third, thank God we had that amendment change, because I'm sure everybody thought we're here to create thought crime laws. Really. And last, performative legislation like this just hides the failure in addressing actual problems of your constituents. I don't know why you tolerate this stuff. I don't know why you write this stuff. It makes no sense.
Oh, I'm sorry. You're
Sorry about
directing
that.
You're
right. You're right.
Your comments to the committee.
Okay. This bill appears to have been written by a conspiracy theorist who wishes to be a lawyer. Do better.
All right. Questions for this witness?
Be
Seeing
happy to
none?
answer any questions.
Seeing none, thank you very much, sir.
Thank you.
Next, I'm going to call on former Representative Betty Gay.
Thank you, Mr. Chairman. Thank you for taking my testimony. That I have very short testimony, and for a person who likes to talk, it's learning to speak in 3 minutes is really good. Previous versions of this bill were loosely written, and I know one of the reps that I used to sit next to, I heard him criticize it and say, we should get all the information that we can, because that bill was written so that some people misinterpreted it to mean that you couldn't access information from international organizations. This bill does not prohibit any kind of free exchange of information. What it tries to do is prevent adopting things from outside that we came across as mandates. Excuse me. I'm not sure with our experience with COVID, if all the dictates that were passed around the world that unfortunately were copied here, I'm not sure if it was on a written mandate or just convincing people through the media, but the result was as if we were being mandated. We had school closures, business closures, mandated masks, mandated vaccines if you wanted to keep your job in many, many places. So this is a preemptive statement that we should make up our own minds about what our policies should be and not ever let an outside international organization mandate what we should do. And certainly it sounded like some of the organizations did try to do that. So this is a protection for future needs the next time we have to deal with something that the world is concerned about and thinks they have the solution. We need to be able to think of what really is our best and safest course.
All right. Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Nancy Vaughn, please.
Good morning. For the record, I'm Nancy Vaughn, Government Relations Director for the American Heart Association in New Hampshire. It's my pleasure to be before your committee this morning. I don't believe I've ever been in your committee, but I am providing testimony to share my organization's concerns with the potential impact of this bill. Primarily as it may impact local communities, passing policies and discouraging sound public health policy at the local level. The American Heart Association supports science-based policy solutions at all levels of government, recognizes the importance of local policy making to promote and protect public health and advance health equity, and believes in protecting local governmental power to advance the health and well-being of its community members. The association advocates for public policies to create environments where people can easily make healthy choices, physically active lifestyles, nutritious foods and beverages, living tobacco-free. We want everyone to benefit from smart and effective policies that promote health, safety, and civic engagement, where community members can participate in developing solutions, voicing opinions, and having opportunities for expressing public support or opposition to policy change. So our concern is really whether this would have a chilling effect on any action at the local level to address issues that impact that community, even when action would be supported by a majority of residents and local leaders. So I'll end my testimony. Thank you very much. And hopefully, if you do have any questions, I might be able to answer.
Great. Thank you very much. Are there questions for this witness? Seeing none, thank you very much, ma'am.
Thank you.
Next, I'm going to call on Aubrey Friedman, please.
Mr. Chairman, committee members, Aubrey Friedman. I live in Bridgewater. I speak in support of this bill. So as was mentioned, we don't have control over the federal, what goes on with the elections. Administrations come and go, members of Congress come and go, and we should be concerned with the future, because maybe things might be okay for a while, but politics change. These three organizations are all rogue, and they should not have jurisdiction here in New Hampshire, especially when it comes to like mandates. Okay, the World Health Organization, so they didn't do a great job during the pandemic, and they've been working on this pandemic response agreement to try to get all the countries to sign on. They've been trying for the last couple of years. They have not been very successful. A lot of countries did not want to sign on to it. They've tried to change it a little bit in the last year to make it more easy to swallow for countries to sign on. And but they've not really changed at all. I went to some of the earlier one, zero draft, and I've got it as part of my backup. I'll pass out afterwards. And if you look at Article 17, it talks about pandemic literacy, implementation of public awareness programs. This is propaganda. That is their thing. If you do not sign on to how they think the response should be to any pandemic or big outbreak that happens, you're in trouble. I mean, it's one, just like it was during the pandemic, the conspiracy theories and all that, if you didn't agree with them. Article 18 talks about national and community levels, this One Health plan. Again, they have one idea for the whole globe, and if you don't sign on to it, you'd be actually in violation if you signed on. And unfortunately, they do not consider the health of everyone, because maybe you read about the $250 that WHO paid out to the Congo victims of sexual abuse. So evidently, they consider the health of everyone except the people that their employees interact with. Sexual abuse, and that was in the Congo during the Ebola outbreak. Okay, the UN, they have not been all that successful in the purpose of preventing wars, obviously, but they've been pushing the small arms treaties for years. The last one was in 2021.
Sir, you seem to be getting a little bit off the subject here of what this bill is about.
Oh, okay. Well, I just wanted to mention each of the three. I talked about the WHO. I'll just make it brief then. Okay.
You don't like the UN. I think we got it.
Okay. And the small arms treaties. Okay. And then the World Economic Forum. Everybody knows about the Great Reset. They scrubbed that from their website, but you cannot ignore. It's still out on the internet. Klaus Schwab, his statement from 2020: the pandemic represents a rare but narrow window of opportunity to reflect, reimagine, and reset our world. So people were dying, and this guy's talking about opportunities. So this organization has not changed. They're collectivists, and they are elites. So I think New Hampshire needs to protect ourselves and our sovereignty. Those organizations should not be able to reach into how we deal with health or anything. And that's why I support the bill.
All right. Thank you. Questions for this witness? Representative Oregon.
Yeah, so the World Economic Forum is a private foundation, and I guess you have doubts about it. So,
Is there a question?
yes, would you support? Are there any other foundations that we should add to the list, like maybe perhaps Elon Musk Foundation or anything?
I think that's I think that's out of order.
We can stick with the three.
No. I think that question was out of order. We don't need a response. Is there any other questions? All right. Seeing none. Thank you very much, sir.
Thank you.
All right. Is there anyone else who wishes to? I don't have any other pink cards. Anyone else who wishes to be heard on HB 584 FN? Seeing none, I'm going to close the hearing on HB 584 FN. And we're a little early, so we can't open the hearing on 580. You know what, just to give everybody a kind of a preview of what I'm thinking. Here's what I would. Oh, okay. I'm sorry. So here's what I'm thinking. I would like to do, assuming that things kind of work out. We'll have the hearing starting at 10:15 on the next bill. Then at 11 o'clock, we'll start our executive session. What I would like to try to do is to get through what it seems like, based upon my discussions with my caucus and now also my discussion with the ranking member, things that there may not be a lot of dispute on. Try to get through that as quickly as we can. If that takes us to, say, and we'll go until, say, 12 o'clock. Maybe we'll be able to get through a lot of other stuff. Then I would propose that we take a brief recess at noon so that people can have their lunch, and that if anybody wants to caucus on the two bills that we're hearing this morning before we exec them, they'll have an opportunity to do that over lunch. Then we'll resume about 12:30 and finish up. And what I'm really hoping we can do, because I suspect a number of people on both sides of the aisle here would like to get to the budget hearing at 2 o'clock. I certainly would. So I'm hoping that that'll be a way that we can get through all of this and still be done by 2 o'clock. So those of us who want to go to the budget hearing can do that. Okay, that's kind of where I'm thinking. So we'll take about 3 minutes until we can start on 580. Thank you. and I'm going to open the hearing on House Bill 580 FN relative to retaliatory defamation in domestic violence and sexual violence cases. And is Representative Burrows? I'm going to call on Representative Burrows, the prime sponsor. Oh,
Thank you, Mr. Chair and members of the committee. For the record, Representative Anita Burrows from Bartlett, actually Glenn, which is part of Bartlett, and I am here today to testify on HB 580. This is a bill that seeks to prevent retaliatory defamation for individuals who are reporting misconduct, sexual assault, sexual abuse, sexual harassment, or domestic violence. And I think the two key parts of this bill are that it ensures that individuals who speak out about their sexual assault and sexual harassment are not silenced by the possibility of a defamation lawsuit, as long as their statements are made in good faith and without malice. I think that's key. And the second thing that this does, which I think is really important, which the ACLU pointed out to me to help with this, said that this also safeguards the right for someone to defend their name. And it allows those accused of sexual assault or sexual harassment to publicly proclaim their innocence without fear of meritless defamation claims, provided that their statements are made in good faith and without malice. So how did this bill come to us? Quick story. Our group of sponsors was contacted by a survivor of sexual assault. She is somebody who was asked to go for a drink with a long-term colleague of hers. Both of them were attorneys. The next thing she knew, she woke up in a hospital with in a coma. She had been sexually assaulted. And she didn't come out of the coma for several days. And what she said was her immediate reaction was that she wanted to go to court against this individual who she had known for 10 years. And a colleague of hers who was also attorney said, "You don't want to do this. It's going to blow up. This person is high profile. You should just keep your mouth shut," which is what she did. And then she found out that another person had had the exact same experience, and she was mortified and angry at herself that she had not gone forward with pressing the charges. So she made it her mission to try to pass laws that would help protect people from being scared away from anti-defamation lawsuits. Now, I'm sure people in this committee know what retaliatory defamation is, but for the record, it refers to when somebody files a defamation lawsuit against another person, specifically as a means of punishment for that person, using the defamation claim as a tool to silence or intimidate them. It's considered a form of retaliation when false statements are used to harm the other person's reputation in response to their action. And as you know, these are anti-SLAPP laws, and that's a legal mechanism that allows a defendant to intimidate or silence criticism through what is often expensive litigation. And again, I'm sure that you folks follow the news. There's been some very high-profile cases involving defamation lawsuits. There was Johnny Depp versus Amber Heard. And very recently, there are two very prominent real estate brokers from Miami and New York, the Alexander twins and a brother of theirs, who the lawsuits against them piling up. And they attempted defamatory lawsuits, particularly against the first person who made notion of their activities. They went to great lengths to track them down and to try to intimidate them through legal action. And now the law actually makes it easier for a private figure than a public figure to sue someone for defamation. That's because when public figures are in the news, they can often tell their account of the story, and whereas somebody who's not a public figure doesn't have that options. And as I mentioned, there are many compelling stories of victims who did not report an assault, who declined to move forward with legal action for a fear of retaliatory action. Now, the assailant may be somebody who's high profile in the community. It could be somebody's boss. So the power play there is there's a differential in power there, and people know how much it's going to cost to have a lawsuit, and could be 3 figures, 4 figures, 5 figures, and a lot of these women don't have. I shouldn't say women; it's men and women. Know that they're not going to be able to afford that. So, as I said, this bill provides 2 essential protections. It protects survivors by ensuring that those who speak out are not silenced by frivolous defamation lawsuits. Again, as I said previously, if their statements are made in good faith and without malice, it also safeguards the right to defend one's name as long as it is done without malice. So, let's see if there's anything else. So that basically is it in a nutshell. I passed out, I don't know if, I think most of you got it. I passed out statistics from the National Women's Organization about the prevalence of these anti-defamation lawsuits. They're growing in number. It's hard to have statistics here in New Hampshire, but a lot of them initially came from college campuses, but the national statistics show that is widening to other types of cases. And so I think it's important that victims are able to come forward without concern about they're dealing with a sexual assault. They don't need to deal with a frivolous anti-defamation case on top of that. So I will end my testimony here.
All right, questions for this witness? Representative Birch.
Thank you, Mr. Chair. Thank you, Representative Burrows. For those who didn't get a chance to necessarily see the email that you sent around with the statistics, could you give the committee a flavor of both how big a problem this is and how many states have sought to address this problem through similar legislation?
Sure, I'll just pick out some key points here. As I said before, 2017, 75% of defamation lawsuits were filed by male college students and faculty who had been reported for sexual harassment or assault. And since then, these suits have been coming in faster. It's broadened. Defamation, and I know some of these are old figures, but as of 2017, they saw that the defamation lawsuits had risen from 5% of caseloads over the last few years of that. A 2020 report found that being sued for defamation is the 3rd most common form of retaliation reported by sexual survivors in the workplace. And again, you often have that unequal balance of power. 2018, the UN special report called the act of threatening survivors with legal proceedings a form of gender bias. I don't want to go through and read all this. I think some of this kind of expanded with the Me Too movement. And New Hampshire, one interesting thing that I found is that New Hampshire is among a minority of states that doesn't have any kind of anti-SLAPP law. So I think that's an interesting statistic. So anyway, you can go forth and read about some of the other states, but I think I've said it a couple of times. I think the 2 keys here are that we're not only protecting the rights of victims, we're protecting the rights of those who are falsely accused to file a lawsuit. We're not trying to prevent that.
Okay. All right. Other questions for this witness? See none. So I guess I have a question.
Okay.
And the problem that I have with all of what you're saying is can you sort of tell us where you say that 75% of the lawsuits defamation lawsuits were filed by people accused of sexual assault against their accusers. I guess my question is, unless a tribunal of some kind has decided that A, somebody committed a sexual assault, and therefore B, that the person is a victim, how do we know whether when somebody has made a claim of sexual assault, that it's true? And how do we know that it's not true? I mean, that's the problem I have. This seems to shift the balance against the person making, against the person that's accused, where there really doesn't seem to be any. We don't know whether that claim is true or not. So how do we? That's the thing I have the most problem with.
Not being an attorney, I guess I would answer that by saying that perhaps in cases where there's a preponderance of evidence, including DNA and maybe eyewitnesses and that kind of thing, there would be definitive evidence that something happened. We don't know exactly what, and that a defamation lawsuit is not merited.
Right, but this bill doesn't say anything about having that kind of evidence, right? This just says that you've made the accusation. So I'm just curious, and I understand you're not a lawyer, and I don't mean to put you on. But for example, were you aware that, for example, if somebody is accused of sexual assault and is actually convicted, that person could not bring a lawsuit for defamation because it would be summarily dismissed on collateral estoppel grounds. So it's, I mean, and you know, one very prominent public example of that is the lawsuit for sexual assault brought against the president, who was found liable, and he then tried to bring a lawsuit for defamation against the victim, and that was thrown out on either a motion to dismiss or summary judgment because he had already been found liable. So my concern is that this seems to me to say it's sort of along the lines of, well, if I claim to be a victim, even though I don't have to actually prove it anywhere, I get this protection. And that is a real concern to me.
Okay. Let me ask you this, because your background, if we tweak language in terms of putting in something about preponderance of evidence, would that make a difference?
The problem with that is the way that you would determine whether there was a preponderance of the evidence is through a legal proceeding. In other words, that's the whole purpose of either, you know, if you claim that you're a victim of sexual assault, you can bring either a criminal, you can go to the police and ask for a criminal prosecution to be brought, or you can bring your own civil lawsuit against the person you claim assaulted you. And the process in which it would be determined whether there was a preponderance of the evidence is that proceeding. So it's hard for me to understand how one would ever establish a preponderance of evidence unless you actually went to court.
So I guess that goes back to, how do we solve this problem of people being scared to come forward and tell their stories and eventually prosecute somebody, maybe be able to prosecute someone if they're being scared off by these six-figure lawsuits? Do you see any way that we could protect a person's right to come forward and do this suit, and at the same time making sure that these victims have a voice and that they're not silenced by this kind of intimidation, which is very powerful?
I agree that it's an important issue.
Right.
I'm just not sure that this, is the answer. Personally, that this is the answer.
I understand
I can
what
only
you're
speak
saying.
for myself.
Yep.
Representative Manos.
Thank you, Mr. Chair. I think what's envisioned by this is that the victim comes forward, files a civil suit against the perpetrator, and while that civil suit is pending, the perpetrator or the alleged perpetrator then files a defamation suit or threatens to file a defamation suit. And so what happens is that the victim is then very reluctant to initially pursue the civil suit, in which, as you point out, a judgment would be made by a jury as to whether there's a preponderance of the evidence to support the victim's claim. And I think this is an intervention to solve that problem, where the threat of litigation excuse me, discourages the victim from even initially filing the civil suit.
I mean, I hear what you're saying, but it doesn't, it say a victim or other person reporting an alleged perpetrator's misconduct. Reporting, what does that mean? That doesn't necessarily mean starting a suit. Maybe it means reporting to the news media. Somebody has sexually assaulted me. And the thing I have the most significant problem with, shall be presumed to have acted in good faith. Wow. I mean, that does seem to me to be, I don't get me wrong. I think that there's a lot of people who are victims who are acting in good faith. I don't doubt that for a minute, but presumed? I mean, that's why we generally put the burden of proof on somebody that's making an allegation. I'm very troubled by that.
Can I respond to that? I mean, and this is a question for you. If like this woman who helped initiate this bill is lying in a coma, there's been a rape test done, and it's clear that she's been sexually assaulted. Is that not enough to show that it's not a frivolous claim? And they can tie the DNA even before trial to the person bringing forth the defamation case.
Well, I guess I mean, I don't know the answer, but it would seem to me I might need more information than, I mean, for example, I suppose one possibility might be that and again, I don't know all the facts, but I mean, for example, if the person who was accused said, sure, we had sex, it was consensual sex, and we got very drunk afterwards or whatever, and she fell and hit her head. I don't know what all the facts would be, but I mean, I guess what I'm saying is, could there be circumstances in which that what happened to the victim would be very compelling? Of course, I completely agree.
Yeah.
But all I'm saying is, this doesn't seem to require any of that. It just requires that you report. And to say that anybody that reports is presumed, that I'm troubled by that. Representative Birch.
If I understand the language correctly, this is a rebuttable presumption. This is a presumption that you start with, but is rebuttable. So if you want to go into court, there is a presumption that when you make a report that you've been sexually assaulted, there's a presumption that you're acting in good faith. Now, the other side, can certainly present evidence to show you're not acting in good faith, and the trier of fact would then make a decision. There's no need, as I see it, to prove the actual fact of whether a sexual assault took place. The problem is the inhibition of, in most cases, women, but not necessarily, a person who wishes to report that they have been sexually assaulted. That doesn't mean proof of it. They wish to report it, and they are inhibited from doing so by the threat or the actuality of being sued by somebody for 6 figures or whatever the number is. So the issue of proving the actual sexual assault took place is, as I see it, a red herring. It's got nothing to do with the harm that this bill seeks to prevent, which is the speaking out either through a lawsuit or in a newspaper or whatever, to say it without fear, if you're doing it in good faith, which can be shown otherwise, if the facts are otherwise, that I was raped, and without a fear of getting improperly sued. And that's what this bill is about.
Okay, well, I'm sorry, Representative Perez.
Thank you. Thanks for taking my question. It's twofold. Number one, I wonder why just these 2 cases. I mean, there are a lot of things that are.
I'm having trouble hearing. I'm sorry.
My first question when I read this was, why in just these 2 incidences are we talking about this? There are a lot of things that go on that unfortunately people do that you could feel that they're, you know, ruining.
Right.
Okay.
Right.
And then my other thing is, I get concerned about, you said so many of them were at college campuses. I get concerned about things because I'm concerned about Johnny and I break up, and I'm really upset. I'm devastated because he's going out with Susie now. And I say, Johnny raped me. I get concerned about that.
Right.
And I probably wouldn't have been as concerned if you hadn't explained that so many of the cases are. I mean, people do nasty things to other people, and if you have no proof that that's what actually happened, if I was Johnny, I'd be filing a case against me
Right.
too. So anyway.
Just in response to the last part of what you said, again, if somebody ends up in a coma and they're all beaten up, that's a different situation than the scenario that you described there.
Well, it says.
Yes, okay, I get that. And the first thing you were talking about is why isn't this broader? Because New Hampshire doesn't have any anti-slap laws, we felt that that we should start with this, and that we should look. I agree, we should be looking at broader anti-slap issues going forward. Again, somebody that I was working on with this bill was concerned about whistleblowers in terms of land waste and that kind of thing. So absolutely, I think that this is an important issue that doesn't just belong relative to this.
All right, other questions for this witness? Seeing none, thank you very much,
Thank
ma'am.
you.
Next, I'm going to call on Pamela Kiley, please.
Good morning, Chairman Lynn and members of the committee. My name is Pamela Kylig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. Thank you so much for the opportunity to speak this morning. As you know, the Coalition is the umbrella organization for our 12 community-based crisis centers located across the state that we provide free and confidential services to thousands of survivors of sexual and domestic violence annually. I'm here to speak in support of HB 580. As you've heard this morning, it's an important legislation that seeks to protect victims of domestic violence and sexual assault against defamation lawsuits. Passing 580 sends a critical message to survivors across the state that the legislature is committed to prioritizing their safety and protecting their right to speak out without fear of retaliation. This bill is a significant step towards discouraging abusers from filing retaliatory litigation, making it safer for victims to come forward and share their experiences. Survivors of domestic and sexual violence face many barriers when it comes to reporting their abuse. We frequently hear from victims across the state about the various tactics that abusers use to undermine their credibility and intimidate them into silence, whether it's contacting their employers, filing baseless motions in custody or divorce proceedings, damaging their credit, or threatening harm to the victim or their children. These tactics are designed to isolate, shame, discredit the victim, and often trapping them in the abusive relationship and making it harder for them to seek help or escape. On average, it takes 7 times for a victim of domestic violence to leave the relationship. The ability of abusers to file retaliatory lawsuits against victims only serves to continue the cycle of abuse, further discredit the survivor, and prevent them from accessing justice. And I think that's an important thing when we look at this. It's not only, this bill was carefully designed to not only strike the balance that someone has to provide particular facts, not a general claim that they have been abused, but that it ensures the right to free speech for victims, just as defendants have the right to free speech. HB 580 not only protects victims, but also serves the broader public interest by ensuring that survivors can speak out with fear of further harm. And I think it is a public safety bill because when victims are silenced, perpetrators are permitted to allow to harm others. So by silencing victims, we're also allowing perpetrators to continue to perpetuate harm. Retaliatory defamation lawsuits create a chilling effect. silencing the victim in a particular case, but potentially discouraging other victims from coming forward as well. This bill is an important safety measure that can help hold offenders accountable and protect the general public. As you've seen in your committee, it can be very scary for victims to share their stories and speak about the abuse they've endured, especially in a public forum. Would you want a constituent who is a victim of abuse to come forward, speak their story, and then have their abuser file a lawsuit against them for sharing their truth? I think that's really the root of this discussion. Do we want someone who is at a work environment who reports that a colleague or their supervisor sexually assaulted them, and then they now have to face a retaliatory lawsuit for trying to get their justice? I think that's really the root of what this is trying to address. The freedom to share what has happened to them is a critical part of their ability to seek justice. And so HB 580 helps ensure that a victim's right to free speech is not infringed, which is important to effectively addressing these issues in our state. I would just say that we have a concern with line 15, paragraph B. Due to the nature and degree of domestic and sexual violence, it is not uncommon for victims to recant or withdraw their statements after they report abuse, whether it is out of fear of further harm or being pressured by the abuser or their family or other reasons. Recanting abuse does not mean that it did not occur. So subparagraph B in some ways undermines the intent of the legislation and reinforces the dangerous notion that victims are not credible witnesses to their own experiences and should not be believed. So I know there was a lot of debate, about the merits of this bill and balancing justice between victims and those that they've accused. But I really think this is a common sense bill to ensure that we are allowing people to come forward and we're protecting our communities by allowing them to do so. So thank you so much, and I'd be happy to take any questions.
Questions for this witness? Yes, Representative Smith.
Thank you very much for coming today and sharing with us your knowledge about this situation. We know that anyone is free to go public to make their statements, and the question here is, will there be retaliation? How do we stop the retaliation? How can we ensure that the accuser in this case is legitimate in the accusation and not using the accusation for other purposes?
I think I'm following your question.
I'm sorry if it was too obscure. I apologize.
No, it's okay. I just don't want to go in the wrong direction. So I'm sorry, could you give an example?
My concern, I think people who have behaved in an unacceptable way should be held accountable.
Yes.
I have no problem with that. The problem that I have is, have they indeed behaved in an unacceptable way? And is it possible that the accuser is doing something that is not quite honorable, and that is exactly what we would not want the other party to do?
So I think, and I would like to just preface that I'm not a legal expert, so I just came in to speak from the experiences we've seen in working with survivors across the state. But I think, it's a legal proceeding that this would take place in, and it's pleading particular facts and not a general claim. So it's not someone just saying that person abused me, but they have to provide particular facts. And so I don't want to jump into the actual what that looks like because I'm not a legal expert, but I do think that that this would be set up in a way to really strike that balance. And I think, again, we're talking about situations where someone could be sharing their story in a public forum, and then the retaliation lawsuit comes forward, and they have to provide those particular facts to demonstrate that they are indeed a victim. So there is a balance there.
So just to follow, I'm going to, but just to follow, I thank Representative Smith because I think she sort of crystallized one issue for me. So if I'm understanding, under this bill, if I claim to be a victim of sexual assault and I bring a civil action against the person that I allege sexually assaulted me, that civil action will proceed as a normal civil action, which means that my burden of proof against the person that I allege committed the assault is a preponderance of the evidence. But if that person claims that I'm the one that's not being truthful, and that I made up a story against that person, and that person wants to bring a counterclaim against me, that person's burden of proof would be clear and convincing evidence. How is that fair? That the accuser gets to bring a case based on, just tipping the scales, but if I want to defend by bringing a counterclaim, I got to establish it much more by a much stronger burden of proof. I don't understand how that's fair.
I would love to just consult with some legal experts on that to provide a more thorough response, but I think that's a great question, and I think the matter of fairness is something that we all try to uphold in matters of justice. So I definitely hear what you're saying, and I wish I had the right answer, but I do think that this is at least bringing up a really important conversation, that there is a challenge that survivors face, and that there are victims in New Hampshire that are being silenced right now out of that threat or fear of intimidation. So I would just ask the legislature to please just consider that something should be done on this issue.
Right. Representative Birch.
Thank you, Mr. Chair. And before I ask my question, I would note that this bill does not deal with counterclaims. This bill deals with a filing of a defamation lawsuit. And this bill deals with the kind of gateway concept of whether that lawsuit should go forward or not. My question has to do with that that section you pointed out about a recantation, and understanding the recantations happen and they're either valid recantations or they're not, and they're recanted and unrecanted and all of that. Given that this is just, as I said, a doorway as to whether a defamation suit can go through, is there really a problem in saying that merely the fact that there's been a recantation is enough in itself, regardless of whether later litigation shows it's a real recantation or not? Doesn't it really make sense to say, well, if there is a recantation, we should let this lawsuit go through the doorway and let the facts develop as they are? So with that view, is there really that much harm in that particular section?
I think that's a great question. And I think from our position, we just caution the committee just to recognize that often there's often pressure to recant in these cases. So I think just given the nature of domestic and sexual violence, we just wanted to flag that paragraph that it could counter sort of the intent of the bill. But I think it's a valid point, and we just wanted to raise that from a victim perspective.
Right. Other questions for this witness? Yes, Representative Manos.
Thank you, Mr. Chair. I just wanted to I don't see where there's a higher standard of proof in the text of the bill, and I certainly don't see where it refers to clear and convincing evidence.
Well, I look at you might want to look at line 8. Unless it is shown by clear and convincing evidence.
That's the amendment.
Yeah, that's in the amendment.
Sorry, I'm not speaking to the amendment. I'm speaking to the underlying bill. I haven't seen the amendment, just to clarify my testimony.
All right, other questions for this witness? Representative Tur.
Yeah, just listening to this, it seems like the goal, and I'm not sure it's in the bill, is to tie the initial lawsuit, which may or may not be part of a criminal case, to what would be the retaliatory lawsuit. You know, not just the threat of it, but maybe the fact of it, such that what we're really saying is, if the initial accusation is borne out, then that person should not have to bear the cost of the retaliation. And I'm wondering, is that in some way read into this, or was that a consideration to basically allow a contingency on a lawsuit like that, such that if the original, you know, accusation is borne out, then that person would be responsible for the costs of their lawsuit?
Yeah, so I think if I'm following your line of question, so the underlying bill, paragraph 4, says a victim who prevails in a retaliatory defamation case at any point in the proceeding shall be awarded court costs and reasonable attorney fees. So I do think that is if I'm understanding what you're asking correctly, I do think that is an important piece of just, again, what the imbalance that currently exists in a lot of domestic and sexual assault cases, where a lot of frivolous lawsuits are brought up, or continued motions and things like that, where victims spend tens of thousands of dollars in court proceedings just because the abuser keeps filing motions. So I do think that, again, within the larger context of what we're seeing in the state, this is just adding another check and balance to what is often a continuation of abuse.
Can I ask one quick follow-up on that?
Of course.
So just on that idea, and this was something I was confused with in reading this, and maybe I'm mistaking which suit we're talking about in the last paragraph versus above, but the up above on line 6, it says shall not file the defamation lawsuit, and then at the end we talk about someone who prevails in a retaliatory defamation case. So are those the same? Like, one of them's preventing it from happening, the other one basically assumes some sort of prevailing result of it. Am I mixing those up?
I think, and this is me, again, not being a legal expert, so I'm going to try my best. So I think because they will bring forward the case, you have to then, the victim would then have to provide particular facts to demonstrate that they indeed are a victim. So there would be costs associated with having to go through the process, I think.
Other questions for this witness? Seeing none, thank you very much.
Thank you very much.
Next, I'm going to call on former Representative Betty Gay, please.
Thank you for taking my testimony. I realize that everybody is concerned about people being falsely I just forgot the word, falsely accused and suffering terribly to their public knowledge. However, in reality, we have far more victims of sexual abuse who then are marked, who are scared to death to say that they've been raped, because the ordinary response for the culture is to say, "What did you do?" So we already have in our culture the reluctance to report sexual abuse. So it takes a lot of gumption, and that's why, as our previous testimony said, usually people go back to their abuser 7 times because there are so many ties, so many reasons why not to risk your entire life and everybody's opinion of you. There are 2 really important facts. One is settling one court case will solve both cases. If you accuse someone of sexual assault and you're found, it's founded, it's agreed that really happened, obviously the second case is not going to happen. So you save a lot of time. Forensics can tell whether a person engaged in consensual sex or was raped. It's no longer considered it's exactly the same. It is not. I think it's really, really important to acknowledge that being threatened with a suit of many figures, of many big numbers, is enough to deter lots of people for lots of things. That is a genuine threat. And in our culture, it's hard enough for victims of sexual assault to prove that they are, or to convince other people that they were not willing participants. So you start out with something that's cultural, not in the law. But I think this bill is very, very important to pass, because it gives, if the person who, I wish my words were better, but if the victim accuses someone and does follow through in court and wins, great. The person's not gonna file against. They could file against them. They still have that opportunity. But if we don't pass this, we're ignoring a really serious threat that victims of sexual abuse suffer from. And I think it's time that we level the field.
Thank you. Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Marissa Chase, please.
Good morning, representatives. Thank you for taking my testimony. For the record, my name is Marissa Chase. I represent the New Hampshire Association for Justice, which is the civil plaintiffs bar of attorneys in the state. I come here with total respect for the sponsors and the intention behind this piece of legislation. Just some practical concerns. With the definitions, I think RSA 507 is maybe perhaps, and I guess I should also preface with, I don't think this is totally unworkable. I don't think every single anti-SLAPP piece of legislation is unworkable. I think there are some ways to do it that might comport better with New Hampshire law. I don't think this bill quite fits that yet. I think RSA 507 is perhaps a weird statute to put it. I think some of the definitions, and I think, Mr. Chair, you brought up a lot of the concerns that, and a lot of the kind of thinking through rational arguments that my members did when we discussed this bill. This bill doesn't necessarily define what a victim of sexual assault is. While a lot of times colloquially, we know inherently what legislation is aiming to get at, legal terms can be quite different, as you all know from your work on this committee. Also, what does the victim publicly stated means? I don't know if anybody's watched The Office, but I'm reminded of when Michael Scott declares bankruptcy. And I also wanted to add that our courts in New Hampshire have found punitive damages at the end. And I'm sorry, I'm reading from the bill as introduced, not any amendment. A victim who prevails at any point in the proceedings shall be awarded costs, reasonable attorney's fees, shall be eligible to receive punitive damages. We don't really have punitive damages in New Hampshire. We have enhanced compensatory damages. Punitive damages are kind of, I should say, frowned upon. The other thing I would note is escaping me at the moment. I apologize. I just completely lost my train of thought. But if there is a will on this committee to work on this legislation and try to come to a compromise, my members would be more than happy to participate with other stakeholders.
All right, questions for this witness?
Yes.
Yes, Representative Birch.
You suggested that thank you for taking my question, and it's good to see you.
Good to see you, Representative.
You suggested that the definitional part of victim or whatever isn't defined. And I'm not sure if you're familiar with the amendment.
No.
Okay, so the amendment says a victim or other person reporting an alleged perpetrator sexual misconduct, sexual abuse, sexual whatever.
Thank you.
So I'm looking here now that you have it at lines 6 and 7, and
so I also think I'm looking at well, I guess I have a concern with line 8, but I'll stick to your question, line 6 and 7. Victim or other person under 170. So I think victim is defined in 173B probably makes sense. But again, I think that creating a rebuttable presumption, I mean, has a criminal case happened or not? When is this civil action being commenced in conjunction with the civil case? And I remembered my train of thought, if I may, to piggyback off this discussion. In New Hampshire, we are such a small state with a collegial bar, and we're a cheap state, right? We're frugal. Juries are the same. And frivolous lawsuits just don't often get filed in New Hampshire. We are not some state that welcomes out-of-state multi-district litigation. We are a small collegial bar where lawyers' reputations depend on their work, and vice versa. And lawyers take these cases on contingency fee basis. That means that a lawyer who would take this case would not get paid unless and until they prevail and get a recovery on behalf of their client. That in itself is a huge deterrent to bringing any claims that are not meritorious in this state. And I just wanted to make that point. But I think the definition of victim of 173B in the amendment makes sense. Clear and convincing evidence. In civil cases, that's just not a standard that we typically see. Civil cases are typically by preponderance of the evidence. Clear and convincing is when you're taking someone's liberties away. It's a much higher evidentiary standard. So I always get wary when we see clear and convincing in civil context.
All right. Other questions for this witness? Seeing none, thank you very much.
Thank you.
All right. Is there anyone else here who wishes to be heard on House Bill 580 FN? Seeing none, I'm going to close the hearing on House Bill 580.
You have 2 minutes. I have some copies of amendments you got to pick up.
Oh, yeah, which
722.
what's that?
722.
722, okay. Wait, hang on one second, 722.
On the fourth floor. I just need to
Yeah, where is 722?
I can do it later.
Oh, okay. Yeah. We're gonna just try to exact out things that I think will be, but then we'll take a break. So. Oh, I'm sorry. Oh, I'm sorry. I'm sorry. I didn't. You reminded me, and I didn't do it. I'm sorry. So, based upon just a very brief discussion I had with the ranking member, let me ask, and I guess I don't, since neither of us, I think, have had a chance to talk to our respective caucuses about this, so I'm sort of, shooting from the hip a little bit, maybe both of us are, but she raised the issue, which I think is worthy of at least a discussion. With regard to the last bill, the bill we just heard, 580, I believe that there would be significant dispute among, and maybe it would be on a partisan basis, maybe not, I'm not sure, but there would be significant dispute about what should happen to that bill. I'm wondering if everyone could live with retain the bill. And what I'm thinking there is this, for example, I'm completely thinking out loud here. This might be satisfactory to some people or not. For example, would a potential way that could bring everybody together on this bill would be if over the summer, for example, we worked on some language that said something like, if a person that is accused of sexual assault or sexual abuse of some kind is adjudicated to have engaged in that abuse, then if it's a criminal case, as part of the criminal case, the court is required to award compensation to the victim for any expenses he or she might have incurred in defending against the lawsuit, or the same if it was a civil case. In other words, a requirement that if you are actually guilty of some kind of assault and you have attempted to use a civil lawsuit against the accuser, you're gonna have to pay the piper if in fact you're found to have engaged in abuse. So I raised that issue as a possibility of something we might think about, and would that be a reason to retain this bill?
Mr. Chair, could I?
Let me hear from Representative Smith first, and then Representative Birch.
I know we're not on the subject of this bill. It hasn't been called for the executive session, so we're not ready at all to discuss it. My only comment to you was preliminary to you getting to it in the calendar, and that there seemed to be strong both questions and affirmations on each side. And because we tried to work as collegially as we can in this committee, it might be appropriate on this bill not to discuss what we could come up with, but to discuss that we ought to think about what we could come up with, and therefore it would make sense to retain it, have a subcommittee perhaps work on it, see what they come up with, see if we can get either to a yes or a no that is clear to all of us. And that was my reason for my comment. Not that I see a suggestion right now. You're much more knowledgeable than I am. You see suggestions now, but rather than go into what I think would be a highly contentious discussion at this point that I don't think anybody wants, it was just when you got to it in the agenda to consider retaining as the answer to get us through to the end.
All right, Representative Birch, you had something you want to say?
I would strongly argue against that. I mean, we've heard, I have some doubts, frankly, that those who philosophically oppose SLAPP litigation or anti-SLAPP litigation are going to come up with a solution that is SLAPP litigation. So I'm not sure what a retention would do. As to the suggestion that if a criminal case proceeds to prove the allegation, then the defamation suit wouldn't happen. We already have that. And the idea if a civil suit shows that the sexual assault happened, that we would switch to a loser pay system, which is not what we have in New Hampshire, and I doubt would ever pass as that concept. I just think that that absent a sense from those who clearly oppose to SLAPP litigation that they're willing to consider SLAPP litigation prohibition, that there's not much point in having a retaining it.
All right.
That's what we're not in executive.
Well, I thought I did open the executive. Did I not open the?
But not to this particular
Well,
bill. You've just opened it generally, and so unless you are taking this bill
Well,
out of
do you-
order, and I would hope you wouldn't, since neither caucus had a chance to discuss this after the hearing, I would hope you would just move on now to the order of the bills that we have
Well,
before us.
okay. I guess I thought that if it sounds like what you're saying, Representative Smith, and if it is the case, I have no problem with this, that you would like a chance to talk with your caucus about this, and that's fine with me. So I will put this off until probably after lunch. I guess what I would like, where's Representative Alexander? He? Okay.
Maybe somebody was.
Pardon? I'm sorry.
Yeah, but the time for that is not now. The
Right,
executive
right.
session's to go through. Is he somewhere?
All right, hang on. Let me. Oh, okay. Hey, Joe, can I?
We were just about to.
Yeah, you ready to go now? Oh, yeah. All right. So, so if I hadn't done so before, I'm going to formally open the executive session now, and I am going to take, I'm going to take up out of order House Bill 633 FN relative to housing investment trusts, because I see at least one or two of the sponsor and someone who's very interested in this bill here, and in deference to not having them have to wait around, I think it makes sense to take that up first. So, with regard to HB 633, the chair recognizes Representative Alexander to speak. I believe he has a motion.
Thank you, Mr. Chairman. I move HB 633 ought to pass, and I offer amendment 2025-0860H.
All right, is there a second? I'll second the motion. And Representative Alexander, would you like to speak to your motion?
Yes, Mr. Chair, thank you. I saw that there's significant value in something like this, and I'd like to study it further. I also think there were a lot of questions raised during the public hearing that could be answered through a true legislative study committee. This amendment would replace the bill with a legislative study committee. It would consist of 3 representatives and 1 senator. The reason why I want to do a legislative study committee instead of a retain is because I want to get buy-in from the Senate or the other body to see, to hopefully get to a point where we can have a clean consensus moving into next year. So that's what this amendment does, and I'm hoping that I can offer up a great version of this bill that the committee will support, and it will fly through the State House next year. So I ask for your support.
All right. Anybody wish to be heard on Representative Alexander's amendment?
Yeah, sure. The way the original bill is drafted is kind of strange too. I aside from the fact I didn't 100% follow the concept, but maybe that's just me, but also like it just defined those trusts, and then didn't make any other changes anywhere in the law books. I wasn't sure what effect just sort of defining these things here if you don't have any other law that says how they operate. So that's definitely an issue that a study commission would probably want to look like. And the advantage of having a study committee, I guess, over retaining it is then you can bring in people from other. There's 3 reps and 1 senator, so you can bring in a senator, obviously, but also you could bring in reps from outside this committee such as from the housing committee. So I guess that's the advantage of having the study committee instead of just retaining it.
All right, anyone else wish to be heard? Representative Smith.
My only comment is I applaud Representative Alexander's optimism that he can get a senator to show up. Thank you.
Other Representative Petterno.
Yes, thank you, Mr. Chairman. Aside from the fact that I wish this had gone to Representative Alexander's Committee on Housing, so we didn't have to vote on a study committee here, I randomly ran into another state rep last week while I was subbing on another committee, and he suggested a similar idea. So I think there is an appetite that I wasn't expecting, and I forwarded this information on to him. And I know he, for one, would like more opportunity to look into this topic.
Anyone else wish to be heard? So I guess I would say I should note I had the opportunity to meet with Representative Daniels and Mr. Delafano, who it was a pleasure to meet with them on Saturday of this week to talk about this bill. And from my discussions with them, I tend to think that this has great great potential. At least it seems to me to have great potential as something that the legislature would want to move forward with. But as Representative Alexander points out, there are a number of things that I think we need to have more information on. I mean, just as an example, 2 things that come to mind to me is, despite Mr. Delafano's efforts to explain it to me, I'm not clear that I completely understand what the interest of somebody who bought a house or a unit under one of these trusts apparently would be referred to as a householder, and I'm not quite sure how a householder's interest would compare with the owner of a fee simple or the owner of an interest in a condominium, that kind of thing. And the other thing is, apparently there is some. This would have some tax implications on the local municipalities, which I think would, is a matter that we would want to get more information on. So I think that the idea of Representative Alexander's study committee, despite the fact that he's going to have to hear from the speaker about his displeasure over study committees, if ever there was one that was worth it, this seems to me it is. And so I support this amendment. And I'm gonna vote for it and then vote for the bill as amended. Representative Birch.
Thank you, Mr. Chair. I want to explain why I will vote against this amendment. I'm concerned that about the tax aspects of this. I'm concerned about the potentiality of sheltering money that would normally go into the state coffers, and I have my own doubts whether the fundamental structure of what this bill attempts to do would be changed by a study committee rather than tinkering with it. So I don't support a study committee.
All right. Anyone else wish to be heard? All right. So we're dealing with the amendment only now. Can I just ask for, is anyone going to require a roll call vote on the amendment? If anyone is, I will do it. If anyone asks for one, I will do it. All right. So can I ask for a show of hands on Representative Alexander's amendment 2025-860H? All those in favor, please raise your hand. All right. Any opposed? All right. So it's 16 to 1. Sorry. All right. Hang on. 33. All right. All right. And then on the, so the amendment passes, we're now on to the main bill, which would be OTPA. Anyone else wish to be heard on Representative Alexander's motion, the main motion of OTPA? Seeing none, I then ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews. Representative Kutab,
Yes.
Representative Perez. Clerk votes yes. Representative McFarland,
Yes.
Representative Smith. Representative Horrigan,
Yes.
Representative Birch,
Nope.
Representative Harvey,
Yes.
Representative Manos,
Yes.
Representative Turr,
Yes.
Representative Rombo,
Yes.
Representative Bergeron,
Yes.
and Chairman Lynn.
Yes.
16 yeas, 1 nay.
All right. And this, okay. All right. Hang on. Give me 1 second. 6:33. All right. I'm sorry. So 16 to 1 on the OTPA, right? Okay.
Are we going on consent?
16. Hang on. TP, right. Yep. Paul, you have any objection if this goes, Paul, Representative Birch, I apologize. Do you have any objection to this going on consent?
Mr. President, I have no objection.
Thank you. All right. All right. Representative Alexander, can I ask you to write the report?
Absolutely.
Thank you. Representative Alexander is actually always very prompt on getting. No, there'll be no minority. All right. Sorry, I'm going to turn to House Bill 620 FN relative to the exercise of the freedom of religion, and the chair recognizes Representative Peternal for a motion.
Thank you, Mr. Chair. I move ought to pass on House Bill 620.
All right, and I'm going to second that motion. Representative Peternal, do you wish to speak to your motion?
Yes, I think this is an important piece of legislation for our state. It is freedom of religion is recognized through the courts, but this would recognize it through statute, and would require compelling interest test, which means that a substantial burden would have to be proven. So it's not just like you're randomly practicing your religion. It would have to be a compelling interest. Does the government have an very good reason to interfere with your right to practice religion? And the least restrictive means, is there an alternative method to serve the public interest? I think this has been enacted in multiple states, and with the increasing number of attacks on religious freedom, it's necessary to implement in New Hampshire.
Anyone else wish to be heard on House Bill 620 FN? Representative Birch.
I'm in opposition to this proposed legislation.
Microphone?
Sorry. I'm in opposition to this proposed legislation. It's not necessary. We have a New Hampshire Supreme Court decision on this very matter. It has set out the law. It's not particularly different than this legislation, since the New Hampshire Supreme Court is ultimately the controlling voice on the constitutionality of such bills, that there's no need to do it. That's State versus Mack. Now, it's been suggested that if the state Supreme Court changed its mind, then we would have a state statute. But that's kind of illusory, because if we had a state statute that didn't pass the New Hampshire Supreme Court definition of or decisions about constitutionality, the fact that we have a statute would be overturned by the Supreme Court. So basically, I don't support passing legislation where there's no demonstrated need for it. It just creates potential conflicts between bodies that are supposed to work cooperatively. We did have testimony also that there's no definition here of religion and religious beliefs, and the the spectrum of what's religious beliefs and not can go pretty far afield, and whether we as a legislature can be involved in defining someone else's religious belief or religion is, I'm not just thinking about the Church of Satan, but maybe a step too far in what we need to do, given we already have a ruling from the New Hampshire Supreme Court. Thank you.
All right. Anyone else wish to be heard? Representative Kutab.
I echo much of what Rep. Birch said, and I also just wanted to add that there was the concern about the zoning related to religious use purposes in relation to this bill, and for that reason, I just can't support this bill, although I do absolutely support the freedom of religion. Thank you.
All right. Anyone? Yes, Representative Horgan.
Yes, I don't agree with the premise that religious freedom is under attack, or at least any more so than any other freedoms are under attack, which, so I'm not sure why an activity deserves more protection or less protection just because it calls itself a religion, as opposed to whether it calls itself something else. So I think, this bill is, I think this bill is, if it does anything useful at all, is probably counterproductive. And in any case, I wouldn't say there was no definition of religion in the bill, but it was sort of a circular definition. But it does refer back to several provisions of the federal and state constitutions. So I'm not sure this doesn't add anything to what's already in the Constitution. It just creates more trouble than it solves. And of course, it's unfair to institutions and organizations, activities that don't describe themselves as religious, as opposed to those which do describe themselves as religious. So I'm not voting for this bill. Thanks.
All right. Anyone else wish to be heard? So I guess I would just, what I would say is I tend to support this. I think that it is important, and I think it's worthwhile to just look at a little bit of history of this. The whole idea of religious freedom restoration acts started after a 1990, I believe, decision by the U.S. Supreme Court that basically said that any law, if a law was of general applicability, the fact that it might have a particular detrimental impact on religion was not enough to say that the law interfered with freedom of religion. That my recollection is that decision by the Supreme Court was greeted with bipartisan condemnation, and it was the Congress of the United States passed the Religious Freedom Restoration Act on by bipartisan vote. The need for a state equivalent to that arose because there was another later Supreme Court case, Flores versus somebody, involving I think in Texas, in which the Supreme Court said that while Congress could grant greater protections to religious freedom in federal matters, it didn't have the authority to do that at the state level. That would be a violation of the 14th Amendment or the Supremacy Clause. And so that's why we have this. It seems to me to be pretty important. I don't see the concern with the zoning issues. If a state or a municipality has some compelling interest for why a church or some religious activity shouldn't be happening in a particular place or whatever, they that will prevail. But it does say that it's got to be something that's pretty important in order for the state to interfere with religious activity. So I think the bill makes sense, and I intend to support it. Anyone else wish to be heard? All right. I see none. I guess I'd ask the clerk then to call the roll, please, on the motion is OTP on House Bill 620.
Vice Chairman Mannion.
Yes.
Representative Alexander.
Yes.
Representative Tripp.
Yes.
Representative Andrews.
Yes.
Clerk votes yes. Representative McFarland.
Yes.
Representative C.
Yes.
Representative Smith. Representative Horrigan.
No.
Representative Birch.
No.
Representative Harvey.
No.
Representative Manos.
No.
Representative Tur.
No.
Representative Rombo.
No.
Representative Bergeron.
No.
And Chairman Lynn.
Yes.
9 yeas, 9 nays.
All right. So, the OTP fails. Is there another motion?
Yes.
Representative Birch.
I would move ITL.
All right. Is there a second? Hang on.
It's Tur.
All right. Any further discussion? Yes, Representative Perez.
This can't go to the floor like this with no recommendation?
Well, we have to have a vote on the on the ITL. I think it then will go to the floor with no recommendation, but we have to have a vote. All right. So an ITL motion has been made by Representative Birch, seconded by Representative Tur. Does anyone else wish to be heard on the ITL motion? All right. Seeing none, I'd ask the clerk then to please call the roll.
Vice Chairman Mannion.
No.
Representative Alexander.
No.
Representative Tripp.
No.
Representative Andrews. No. Representative Kutab.
Yes.
Representative Perez. Clerk votes no. Representative McFarland.
No.
Representative C.
No.
Representative Smith. Yes. Representative Horrigan.
Yes.
Representative Birch.
Yes.
Representative Harvey.
Yes.
Representative Manos.
Yes.
Representative Tur.
Yes.
Representative Rombo.
Yes.
Representative Bergeron.
Yes.
Chairman Lynn.
No, on the ITL, no. Sorry about that. A senior moment.
9 yeas, 9 nays.
All right. All right. So it appears that we will go with, it'll go to the floor with no recommendation. Representative Pedernal, will you write the report for the OTP, and who will write the report for ITL?
I'll do it.
All right. Representative Birch. All right. Birch. All right. All right. Next, you can just
See anybody else raising their hand?
All right, next, I'm sorry, next I'm going to turn to HB 641, relative to establishing a private right of action for civil rights violations. And the chair recognizes Representative Alexander for a motion.
Thank you, Mr. Chairman. I move in expedient to legislate. ITL.
Right. Representative Perez, you have a second?
I second.
All right, so it's moved by Representative Alexander, seconded by Representative Perez. Representative Alexander, do you wish to speak to your motion?
Yes, very briefly. I think the testimony from the Attorney General's office was very enlightening on this. They indicated there are only about 215 complaints last year. 50 to 55 of them rose to a certain standard that it needed to get investigated. And I made a point to ask if the AG feels like they have sufficient staff to investigate these claims and address them, and they indicated that they do. So I just don't think this bill is needed at this time. So I would encourage my colleagues to vote ITL.
All right, anyone else wish to be heard? Representative Rumba.
I just wanted to mention, I don't know that anybody's gotten a chance to see this, but it appears that there's, oh, is that what's just gotten handed out, the amendment? It just came out. We just got notice of a potential amendment from the AG's office, so I just didn't know if there was further discussion on that particularly. This is not in addition to what you were just talking about. Sorry, I just saw an email come in recently and I wasn't sure if we had missed something on an amendment. Just wanted to clarify.
Yes, Representative Garthwaite had emailed the Judiciary Committee just 10 minutes ago saying that there is a potential amendment. I told her if my motion of ITL fails, we can entertain the motion, but actual or threat, I mean, I still, with the amendment, would move ITL.
I just wanted to get it out there. Thanks.
Could we just clarify, because I have an amendment in hand, the number is 0406. Is that the number we're talking about?
No, there's another one that just came in our inbox. It's not a formal amendment. I believe it's just text of an amendment. It's not a drafted one. Representative Garthwaite had sent it to us via email.
So, and so I should say, I didn't see that because I had, I haven't checked my email since last, but am I correct, Representative Alexander, that the substance of that would be to allow the Attorney General to intervene in cases?
I think that's the amendment 0406 that we all have and should be moved. That has the right to intervene.
No.
I don't know what the one I haven't seen yet says.
There's new language that would add a sentence saying if the court or jury finds that the actual or threatened use of force, violence, property damage, or trespass was a willful or knowing violation of this chapter.
Okay.
That's the additional sentence.
All right.
I think Representative Garthwaite's not nodding at me.
Mr. Chair.
So Representative Birch.
I know it's proper, not often done at executive sessions, to ask somebody who's not on the committee perhaps to speak, and I see the representative is here, and maybe the representative can explain the bill for the amendment. If we're discussing the amendment.
Well,
she's here.
I guess what I would say is, we don't have a drafted amendment. This bill was noted for executive session in proper form. Representative Gathright, I guess, yes, if you want to speak very briefly to what the amendment does, I think that really is the only thing. That's not to say that we're necessarily going to take up the amendment, but I think it's appropriate to hear what you have to say about it.
Thank you, Mr. Chair and Judiciary Committee. My name is Linda Harriet Gathright. I'm out of Nashua, Ward 9. So I just received, unfortunately, I just realized that it was sent to me at 9-something this morning, but I was back here on my computer for the first time today and saw it. That it was sent to me by the AG office, by Sean. And so I wanted the opportunity to get the amendment. And that's what made me send you guys the statement that he made. This was something that was in the hearing, section 2, I think, of the bill, that he wanted to make a change. It's not the one that he made the change on the original that you have there that allowed them to have access. But this is totally different. And I think this is something that Representative Birch had brought up and had the conversation.
So, all right. So is this something that deals with the language about a settlement?
Yes.
Okay.
This is in section 2.
Okay.
I'm just getting to see it myself, actually.
Okay. Oh, sure.
I literally just saw this when I sent it to you all.
Okay.
So I haven't sent it, but I can send it over to them, and if you would hold off to later today.
I mean, it's well. Anybody else have any questions for the Representative?
Yeah, Mr. Chairman, I just want to make sure I'm understanding correctly. I see the email, but I don't see any attachment from OLS. So is it just the language in line that's not been written up by OLS?
Yes, this is the language that was sent to me to send to OLS.
Okay, so there isn't actually an amendment from OLS though.
Right.
Okay.
Right. So, all right, Representative Oregon?
Like Sean Locke, who's an assistant attorney general, he sent us the proposed language, I guess, sent it to her and then another individual in the text of the email rather than as a file attachment. But
Right.
I
All
mean,
right.
OLS probably could.
All right.
But there's enough there for OLS probably to.
All right, thank
a
you very
formal
much,
amendment.
Representative Gothright. Appreciate it. So,
Thank you.
it sounds like, I'm sorry, Representative Smith. Oh, no, I guess what I was going to say is, it sounds like the language that, if I'm understanding correctly from what Representative Mannion showed me, it doesn't sound like this language really would have any effect, at least in my view, and I think in Representative Alexander's view, I suspect in the view of at least my caucus, on how we would vote on this bill. So, in light of that, I'm not inclined to go further with the amendment. Representative Smith.
Mr. Chair, I might have misheard my longtime dear colleague from Goffstown about when he talked about the numbers of people. I wondered if he could tell me what number of people denied their civil rights would be acceptable before the state should step in. I think he said something like 24. That's obviously below his standard. Could he tell me what the standard would be?
There is currently nobody's. Thank you for the question to my dear friend from Durham. There is currently nobody being denied civil rights violation that's not being adequately already invested by the AG's office. This bill is not needed.
All right. Anyone else wish to be heard on this? So I guess I should say, because I had a discussion with Representative Gothright last evening, I listened to the entire hearing on this bill, and what I was taking away with were a couple of things. First of all, I think it's really important to understand that it is not true that at the present time there is no basis for an individual to bring a claim who has had their civil rights violated in the manners that are described in RSA 354B. As I looked at the statute, and based on the common law, it would be a rare case in which something that would violate RSA 354B would not also very likely amount to a common law tort of assault or battery or false imprisonment or defamation or invasion of privacy or some other common law tort. Now, could there theoretically be some? I suppose it's possible. Would the remedies? I mean, one of the things that I remember hearing from the testimony at the hearing was a concern that, well, a court, it's only under the statute that a court could grant injunctive relief. That's not my understanding of the law. If somebody brings a common law lawsuit and alleges that somebody assaulted me and there's a threat that they're going to continue to assault me in the future or harass me or do whatever, you can get an injunction in that circumstance also under the common law. I think courts are fully capable of granting that kind of relief. So I think that really builds upon what Representative Alexander had said, that this legislation is just not necessary. And again, the other thing that I think was very important that Mr. Locke indicated in his testimony was that this is not at all a situation where the AG's office is overwhelmed with cases that are brought to their attention and they can't bring or seek relief for all the cases that exist. That he said that their office is fully able to handle the cases that are brought to them. So that, again, reinforces Representative Alexander's position. For those reasons, I intend to support the ITL motion. Anyone else wish to be heard on this? All right, seeing none, I would ask the clerk to call the roll. The motion is ITL on House Bill 641.
Vice Chairman Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews. Representative Kutab,
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland,
Yes.
Representative C,
Yes.
Representative Smith. No. Representative Horrigan,
No.
Representative Birch,
No.
Representative Harvey,
No.
Representative Manos,
No.
Representative Tur,
No.
Representative Rombo,
No.
Representative Bergeron,
No.
Chairman Lynn.
Yes.
10 yeas, 8 nays.
Representative Alexander, could I call on
Yes.
you to write the majority? What, I'm sorry?
What is the count?
It's 10 to 8.
10 to 8?
Yes. I think.
Get to be 10 to 8.
We have a sub.
But how did you vote, Representative Kutab?
She voted, I think, Representative Kutab, did you vote yes? Is that correct? Yeah, it's 10 to 8.
I'm very sorry. I thought she voted no. I apologize.
All right. So Representative Alexander will write the majority report. Who will write the minority?
All right.
Oh,
No, wait, did somebody else?
yes, somebody. All
Oh,
right.
good.
Rombo, minority. Okay.
I have a question of the chair. Since there was we did have that email chain with the proposed amendment in it, so would that have to be a floor amendment if somebody wanted to move forward with it, or could it be a minority amendment? Or OLS hasn't drafted it yet.
It wasn't I suppose yeah, I think it would have to be a floor amendment. If the ITL motion fails, then there would be an opportunity for another motion.
Yeah, because what he had looked like he could very easily be drafted, but it hasn't been drafted.
ITL would be the majority.
Right.
The minority would be OTPA with the floor.
With a floor amendment, right. TPA. Rombo.
And Representative Rombo would have to have a floor amendment drafted, and she can get the information, obviously,
Right.
from either the Attorney General.
All right. Santa Cruz. No, you're right. You're right. I know, that's, let me see. All right. I'm just gonna see. Let me see what else I wrote down. All right. So, Representative Alexander.
I have a sample green sheet. None of these things are on it.
All right. All right, next, I'm going to take up House Bill 666 FN, and the chair recognizes Representative Alexander for a motion.
Thank you, Mr. Chairman. I move ought to pass, and I offer amendment 2025-0332H. First of all, I'll wait for a second, and then I can speak. 0332H. I had distributed to the committee a few weeks ago. I have copies. I can hand those around too. Here.
Great. All right, so let me, hang on, let me back up. So Representative Alexander moves his amendment, and I'm, for the record, I will second that. And Representative Alexander, do you wish to speak to your on the amendment?
Yes, so it should be no surprise to the committee that this is a great bill, and I think you should vote for it. There were a couple things raised during the public hearing. So this amendment makes two changes. First, it addresses it does the address of library card, library membership status, keeps that, but it removes on line 16, it used to be any member of the public, library or library staff. It removes member of the public. So it's just library or library staff. And then it doubles the civil penalty from 500 to 1,000. But it doesn't, it changes the term restitution payment to civil penalty, which was a suggestion during the public hearing.
All right. All right. Anyone else wish to be heard on the amendment to 666? Oh, yes. Yes, ma'am.
Thank you, Mr. Chairman. I was actually here for the hearing of this bill, and I'm also a member of NHLTA. I have no problem with library cards and library membership status being private and not open to the public. And I believe this committee already passed a bill that did just that. I do have reservations with the damages that are being assessed. I thought even the original bill of 500 with the apology that's notarized in public and so forth, I just feel that like the damages are way beyond what the crime, so to speak, is. You know, these sometimes in small libraries, library staff people only work very minimum hours during the day, and something might have happened that they are not even sure about. So I just don't like what is being asked of these people who might have made a mistake that they didn't even know that they were making. It seems kind of on the order of public flogging to me.
Anyone else wish? Yes, Representative Perez.
I support this 100%. I do not believe that not knowing what the law is an excuse for not following the law. If I get stopped for speeding, can I say I didn't know that the speed limit was 60 and I was doing 80? So I support it.
All right, Representative Horgan.
Well, in the speeding is usually less than a $500 or $1,000 fine. So just as I just want to underline what Reverend Harvey said, that this bill moves in the wrong direction in that regard. That it's it's $500 was already an excessive penalty, so 1,000 is twice as excessive. And also the whole rigmarole about being forced to apologize and notarizing your apology and sending it certified mail. Which actually, though, is an inconvenience for the person who also receives the apology, since you get this scary looking slip of paper that your mail carrier drops and you have to go to the post office, etc. So that's, so I think the whole thing is excessive and the amendment moves in the wrong direction. And of course, I also didn't quite understand what the basic rationale for the bill was either. But so for all those reasons, I vote against the amendment, which makes a bill that I didn't think was good and makes it slightly worse. So thank you.
All right. Anyone else wish to be, or Representative Tur?
Yeah, just adding on to the sort of excessive nature, I think, of this bill. I just wanted to clarify, this is my reading of it, since the penalty is payable from the violator to the aggrieved individual whose information was released. It seems like if a library staff person, not even a librarian, any individual on staff, if they were to say accidentally mail out a list that had some librarians had some list of people who had library cards, they would be paying up to $1,000 per individual so this could run into the hundreds of thousands of dollars for an individual, not the library, but an individual. That seems excessive for what we're talking about.
All right. Representative Birch, and then Representative Alexander.
Yeah. Following up that, I join in those that feel the purpose of the bill and the first section is fine. but there are troubling aspects on the penalty end. One of which is it's one thing for the state to fine people for violating a statute, and then having that money go into, the general fund or wherever it goes. What this bill attempts to do is use legislation to accomplish what a civil suit would do. And it would replace, if my library card was, library card status, and I do have a library card that's very old, if my status is disclosed and I feel like suing or speaking to the person, I can, and I could sue for damages or whatever, and those damages could be shown, reputational or otherwise. That's fine. To have the state do it for me and turn the money over to a private individual is heading, I think, in the wrong direction. I'm also, of course, my town's a small town. We have a very small library. We have, I think, 1.5 people that are involved in it. They do the best they can. They don't get involved in politics at all, at least in their official capacity. And as Representative Tur suggests, this is an open-ended policy if a list goes out or legislation that could amount to tens of thousands or hundreds of thousands of dollars for this individual who, if they were acting in their capacity as a town employee, should more properly be a tariff or penalty that the town pays. But this bill makes it on the back of the individual staff member or librarian. And frankly, in small towns, I don't know about Goffstown because it's a large town, but in small towns, it's hard enough to get volunteers to work at places like libraries or work for a very small amount of money or volunteer for boards or this, that, and the other. But to say, if you make a mistake while you're doing your job and you made a mistake, and it's going to cost you personally untold amount of money, that's going to make it really hard to get people to work at libraries. Thank you.
All right. Representative Alexander?
Yeah, very briefly. Thank you, Mr. Chair. Representative Birch paints such a great picture of what a small town library should look like. He portrays his small town library as one that doesn't make political statements and isn't an activist library. And I don't think necessarily all libraries are like that. And so while I appreciate that his library is like that, there are others in the state that they're not. So this bill is a simple bill that makes it so that public libraries do not violate somebody's privacy. And if they do, it's $1,000 fine. I don't understand why it's as contentious as it is. I think protecting people's privacy is one of the duties of our committee.
All right. Representative Smith.
Thank you very much. I certainly agree that protecting privacy is one of the important roles of this committee, and we have several bills that we'll be voting on today that work to protect privacy. I'm not sure that this bill is one to fall in that category. We all know and sometimes are amused by our colleagues who come in here and have been upset by a decision that was made in their local town. I think of one of our representatives who came in last year because he wanted to hold a meeting and a particular facility said no, they wouldn't permit that meeting, and so he wanted us to have a bill. My feeling on that bill was what ought to happen is he ought to figure out how to talk with the people in his town to get an accommodation. This bill is one of a series that we have had before us and that we have treated respectfully that came out of a particular situation in a particular town. in which a court ruled that in fact the library had not done anything wrong, had not done anything political, but still there is a lot of anger. That town had an election yesterday, and to vote for people to be library trustees. And as I understand it, the winners in that election were people who thought that they had respect for the library and the way the library was functioning and didn't need anything else. I don't think we should use the power and the integrity of the Judiciary Committee to try to appease the anger of one or another, whether it's a person on our committee who we respect and love, or whether it's a person who's not in our committee and respect and love. This is over the top. The fine is unbelievably inappropriate. The public apology is totally irrelevant unless things have come to the stage where we're going to build something in front of town hall, build stocks in front of town hall where we can periodically put people we don't approve of in the stocks. And I don't think we're there yet. I don't think we should pass the bill no matter how much we like the sponsors.
All right. Representative Horgan, if you have something new, I'm sorry,
Yes.
Ramanos, were you?
Yes, just in the,
Hold on.
well, just in the interest of full disclosure, I realize I actually have 3 library cards I'm carrying around with them. One of them is from a library located in another state. It's not in a jurisdiction, but I do have not one. I have cards from the Durham Public Library and the UNH libraries. And by the way, I think anybody in the state. So I just want to say I have nothing to hide on this issue about.
Okay.
I do confess to having library cards. So.
All right, Representative Manos.
I just wanted to add to the discussion that if there's a factual dispute about whether there was explicit consent, there's no due process in this bill. There's no adjudication. There's no process for determining what the facts are, and I oppose it for those reasons. In addition to the others.
All right. Any other comments? So I guess what I would say is I think I intend to support the amendment. Do I swallow a little hard about the amount of the fine and the apology? Yeah, but I defer to the view of my colleagues in my caucus on this, and so I intend to support it. All right, so I guess the first thing is a vote on the amendment. I will do a roll call vote on the amendment if anybody wants it. Does anybody want?
I would like a roll call vote.
All right, so we'll have a roll call vote on amendment 2025-0332H to House Bill 666. So I'd ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland,
Yes.
Representative C,
Yes.
Representative Smith,
No.
Representative Corrigan,
No.
Representative Birch,
No.
Representative Harvey,
No.
Representative Manos,
No.
Representative Tur,
No.
Representative Rombo,
No.
Representative Bergeron,
No.
and Chairman Lynn.
Yes.
10 yeas, 8 nays.
All right, so we're now on to the main motion of OTP, moved by Representative Alexander, seconded by me. Does anyone else wish to speak to the main motion of OTPA? Seeing none, I would ask the clerk to call the roll on the main motion of OTPA with Representative Alexander's amendment.
Vice Chairman Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez,
Yes.
Clerk votes yes. Representative McFarland,
Yes.
Representative C,
Yes.
Representative Smith,
No.
Representative Horrigan,
No.
Representative Birch,
No.
Representative Harvey,
No.
Representative Manos,
No.
Representative Tur,
No.
Representative Rombo,
No.
Representative Bergeron,
No.
and Chairman Lynn.
Yes.
10 yeas, 8 nays.
Representative Alexander, it sounds like you may be up again. For
I would love to write this report.
All right.
Thank you.
And I will do the other.
All right. And Representative Smith, you will write the minority report?
Yes, I will.
All right. All right. So that takes care of 666. Let me just see. Hang on. Give me 1 second. All right. Next, I'm going to take this a little bit out of order, but I think it's appropriate. I'm going to turn to HCR 11, and I'm going to recognize myself, and I move to retain HCR 11. Is there a second?
Second.
All right, so it's been moved by Representative Lynn, seconded by Representative Manos, and I, and I apologize. And I would, I just speak very briefly to this resolution. I have to say, I'm just going to say candidly, there's a great deal in that resolution that I am very sympathetic to in terms of separation of powers issues. I think this is not an appropriate time for us to be issuing a resolution like this, where there is a matter that the resolution deals with that is pending before another branch of government, the Supreme Court. So I think that the most appropriate thing to do is for us to retain this for perhaps another occasion when it might make more sense. And that's all I'll say about that. Anyone else wish to be heard on HCR 11? Yes, Representative Manos.
Thank you, Mr. Chair. I just want to clarify your intention. You want to retain it but not work on it. You just want to hold it for future consideration?
Well, I perhaps work on it. I mean, have I sort of gone through line by line and scrubbed every line to see if I might change? No, I haven't done that. So to the extent that could there be some changes? Yes. But I think you are also correct that I think that timing is very important, and I think this is not the appropriate time. Representative Smith.
Yes, I agree with you, Mr. Chairman, that this is not the appropriate time for this particular HCR. I actually believe that there is no time that is appropriate for this. And I believe that I have been elected by my constituents, not by my caucus, not by party leadership, but my constituents, to carry out my responsibilities, which include a respect for the Constitution of this state and a respect for the importance of separation of powers, so that if I had an opportunity to vote on the merits of this bill, I would be voting no, or in the vernacular, ITL, and I will therefore also be voting no on retain, clearly not because I then want to have an ought to pass motion. Thank you.
All right. Anyone else wish to be heard? Representative Horgan.
Two practical considerations is, first of all, the rules of the other body, they need a 2/3 vote even to consider an HCR. So it's not, even if this even if we send it over there, I suppose we shouldn't speculate about what somebody would do, but there's more likely than not to not even take this up. But also, we're going to one way or another either pass a budget or a continuing resolution before a retained bill hearing could be held, and that will presumably. I guess once again, maybe I shouldn't speculate even about this body do, but I think there's a very high probability that it'll be similar to past budgets. So there'll be controversy over it. There'll be more court cases, but it's probably not going to settle the objections of the various court decisions that have been made over the years, even though those court decisions are based not just on the state constitution, but also on a statute, which I guess was passed 32 years ago. And we're in our 16th or 17th budget cycle since that series of lawsuits started. But as a practical matter, we're probably going to pass a budget which probably will not satisfy those who brought the lawsuits that we're objecting to. So,
All right. Anyone else wish to be heard? Representative McFarland.
While I certainly concur with you, Mr. Chairman, that the timing of this is not ripe at the moment, I also feel I would be doing my constituents a significant disservice if I didn't work to ameliorate the language, so I'm supporting retain.
Representative Birch.
Thank you, Mr. Chair. I will vote against retaining because I don't personally believe, as suggested by Representative Smith, that there will ever be a time to pass a bill that is so disrespectful of another branch of government that this is, that in the very first paragraph, quoting the Constitution of the state of New Hampshire, the bill doesn't even fully quote Article 37 of Part 1 in full, but it leaves out the section that says, as consistent with that chain of connection that binds the whole fabric of the Constitution in one indissoluble bond of unity and family, and amity. So I will vote against the motion to retain, and should that motion be defeated, vote against the bill.
All right. Anyone else wish to be heard? Representative Manos.
Thank you, Mr. Chair. I believe strongly, very strongly, in the separation of powers. And I think it's completely inappropriate for the legislature to be dictating to the judicial branch what the outcome of cases or the providing guidance on cases. I think it's totally inappropriate. But in addition to that, I would point out that this is a House concurrent resolution. It has, even if it were passed, it has no force of law. And for those two reasons, I will vote against retaining and against the underlying bill.
All right. Anyone else wish to be heard? All right. Seeing none, I would ask the clerk to call the roll. The motion is to retain HCR 11.
Representative Mannion, I'm sorry, Vice Chairman Mannion.
Yes.
Representative Alexander.
Yes.
Representative Tripp.
Yes.
Representative Andrews.
Yes.
Representative Kutab.
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland.
Yes.
Representative C.
Yes.
Representative Smith.
No.
Representative Horrigan.
No.
Representative Birch.
No.
Representative Harvey.
No.
Representative Manos.
No.
Representative Tur.
No.
Representative Rombo.
No.
Representative Bergeron.
No.
And Chairman Lynn.
Yes.
10 yeas, 8 nays.
All right. So the bill will be, HCR 11 will be retained. All right.
Just lower all these.
Okay. Okay. That's fine.
All right. Next, I'm going to take up HR 7, instructing the House of Representatives to investigate whether grounds exist to impeach Judge David Ruoff, and the chair recognizes Representative Smith or her designee for a motion.
Thank you, Mr. Chair, for giving me the honor of moving ITL on HR 11.
All right. I will, so Representative Smith moves. I will second that motion. And Representative Smith, do you wish to be, to speak to your motion?
I'm hesitating because clearly my mood today has gotten a little more insistent than is usually the case. I find that the bill having been introduced is even offensive to the principles of the government of the state of New Hampshire. And to threaten to impeach a judge, not for having his hand in the till, not for inappropriate personal behavior, not for anything else, but because someone doesn't like the decision, to me is even worse than wanting to penalize an employee or a volunteer in a library because a mistake might have been made. This is the highest insult that I think we could be part of, and I do not want to be part of that insult.
Anyone else wish to be heard on this? So I guess I would really echo Representative Smith's position. You can agree or disagree with Judge Ruoff's decision, and I have to say candidly, I have significant issues with the decision. But the idea that we are going to impeach a judge for his decision is, I think it would be unprecedented. I'm not aware of anywhere. Maybe there is, somewhere in, Alabama in the 1870s or something, they did something like this, but I can't imagine it. It is, it's just, candidly, it seems to me, it's beyond the pale. I have to say, all candor, I know Judge Ruoff. He is a good person. He's a smart person. He's a good judge. And whether he got this one right or not provides absolutely no basis for impeaching him. And so for those reasons, I intend to support the ITO. Representative Paterno.
Thank you, Mr. Chair. I agree with what you're saying. However, I just want to clarify that this resolution is instructing the House of Representatives to investigate whether grounds exist for impeachment, not the actual impeachment.
No, I agree with that. I do agree, but I think it's clear from the line. There's no suggestion of anything else that Judge Ruoff did except issue this decision. So it would be, what will, if we were to actually have an investigation, what would it be? I mean, about whether he issued the decision. So I do agree with you completely, Representative Paterno, but that's the way the resolution is worded. But that candid, it just seems to me that's a smokescreen, because the only basis for launching the investigation is his decision. So anybody else wish to be heard? All right. So the motion before us is ITL on House Resolution 7, and I'd ask the clerk to please call the roll.
Vice Chairman Mannion.
Yes.
Representative Alexander.
Yes.
Representative Tripp.
Yes.
Representative Andrews. Yes. Representative Kutab.
Yes.
Representative Perez. Yes. Clerk votes yes. Representative McFarland.
Yes.
Representative C.
Yes.
Representative Smith.
Yes.
Representative Horrigan.
Yes.
Representative Birch.
Yes.
Representative Harvey.
Yes.
Representative Manos.
Yes.
Representative Tur.
Yes.
Representative Rambo.
Yes.
Representative Bergeron.
Yes.
And Chairman Lynn.
Yes.
18 yeas, 0 nays.
Any reason that can't go on the consent calendar? And
Mr.
Representative-
Chairman, do you want to write the book, or do you not?
Yes, if you don't mind, I would like to write the report on this. I'll write the majority report. All right. Can I just take one more? Okay. Take a minute.
Sorry, I just don't want you to walk out.
Yeah, when we're about to
Break
vote.
up.
I'm going to do one more, and then we'll take. Okay, good. Sorry. Excuse me. I'm going to now turn to House Bill 584. And the chair recognizes Representative Kutab for a motion.
Thank you. I move ought to pass with amendment 2025-0966H.
All right. Hang on one second. Four. All right, is there a second to Representative Kutab's motion?
I'll second.
All right. So moved by Representative Kutab, seconded by Representative Mannion. Is there, Representative Kutab, do you wish to speak to your motion?
Briefly, so what this amendment does is it fixes currently in the foreign pharmacy graduate statute, it lists the World Directory of Schools by the Pharmacy published by the World Health Organization. In the bill, it had given an alternative list for the physician foreign medical school graduate licensing, but an equivalent doesn't exist for the World Directory of Pharmacy Schools published by the WHO. So I think it's really important that we ensure that this bill won't interfere with the licensing of our pharmacists who are foreign pharmacy school graduates. And so this amendment seeks to fix that.
All right. All right, anyone else wish to be heard? Yes, Representative Smith.
I'm a little surprised that this was called because we just heard it this morning and we haven't had a chance to discuss it among ourselves. But whether I support the amendment or not, I think is irrelevant because I would strongly oppose the bill and would have liked to have had the opportunity to discuss it among ourselves.
All right. Anyone else wish? Yes, Representative Horgan.
Well, this amendment, first of all, it doesn't incorporate the changes that the prime sponsor recommended, which, I'm not particularly don't have a particularly strong opinion one way or another about whether that particular change was good. It also, although this would eventually be caught by the clerk during the enrolled bill process, there's a typo. It's the possessive form of the pronoun anyway, it should say ITS and it says IT apostrophe S. So IT apostrophe S means it is. And so like what they meant was it's the possessive form of it. So that's, those are two things that are missing from this amendment. So, which
All right. Anyone
probably
else?
should be.
I'm sorry, Representative Tur.
Yeah, I just want to point out, I mean, a bill about groups that have no jurisdiction within the state, clarifying that they have no jurisdiction within the state. There's any number of things that could fall into similar categories, and I feel like opening the door to legislation like this is wildly inappropriate.
All right. Anyone else? Yes, Representative Perez.
I just want to I just want to remind everybody that a while ago, the World Health Organization and Joint UN Program on HIV and AIDS recommended voluntary medical male circumcisions as part of measures to prevent HIV infections in Africa. They found 23 million African men were circumcised, and then they found out that that absolutely did absolutely nothing to prevent the spread of AIDS. So I don't want that to happen to us.
All right.
not going to happen.
Anyone else wish to be heard on amendment, Representative Kutab's amendment 0966H? Seeing none, can we do this by a show of hands, or do people want a roll call?
Show of hands is fine.
All right. So on amendment 2025-0966H, can I ask all those in favor of the amendment, please raise your hand. Whoops. I'm sorry. Wait a minute. Let me start again. What? Everyone, keep your hand up if you support the amendment. 11, 12, 13. All right. 13. And those opposed, please raise your hand. 13, 5. Passes. All right. All right. So the amendment passed. So now I'm going to recognize myself, and I'm sorry. No, that's what I was going to say. I was going to do this. You're talking about Representative Granger's amendment, right? Yeah. No, I do. So now I'm going to actually, if you're prepared to do it, I'll recognize you. Do you want to move Representative Granger's amendment?
I move amendment 2025-0683H.
All right, and I'll second that. Representative Kutab, do you wish to speak to your amendment?
So this amendment merely changes the part regarding creating and enforcing policies to enforcing policies that are from the World Health Organization, UN, or the World Economic Forum.
All right. All right. Anyone else wish to be heard on amendment 0683H? Yes, Representative Manos?
Thank you. I'm just not clear. Perhaps Representative Kutab could explain a little further what this amendment does. I'm not clear on what this accomplishes.
Thank you. So what this amendment does is, if you look on line number 12 of the amendment, in the original bill, what it said was create and enforce, and now it's just says who enforces instead of including also create. So it's just changing it to enforces.
It's just those two. Yes, Representative Horgan.
Well, it actually does a second thing. So the first bill is introduced only said enforces policies, but this also adds mandates, orders, requirements, edicts, or directives of those organizations. I guess presumably if they were to issue a mandate, order, requirement, edict, or directive, which was not, however, a change in policy, that would now be covered by the bill as amended, which they would have been excluded from the original bill. So that it does do a second thing. So,
all right. All right. Anyone else wish to be heard on amendment 2025-0683H? Seeing none, then can I ask for a show of hands, all those who would be in favor of the amendment 0683H, please raise your hand. 2, 3, 4, 12. All right, 12. And those opposed, please raise your hand. 6. 12 to 6 passes. All right. All right. So as I've looked over the two amendments we've discussed, that is 0683H and 0966H, they do not appear to me to in any way conflict. So I think that there's not a problem with that. And what I would do if the bill passes, I would ask our assistant to ask the OLS to prepare a consolidated committee amendment that will reflect that. So I think we're now on to the main bill, House Bill 584, as amended by both of those amendments. And Representative Kutab, do you move ought to pass as amended with the two of them?
I will.
Or I'm sorry, Representative Mann.
Yes, I move ought to pass as amended on House Bill 584.
All right, and I will second that. All right, anyone wish to be heard any further on the, yes, Representative Birch.
So what we have here is legislation based on something that suggests that these particular organizations have ever issued an enforceable mandate on the people, citizens of the granted state. To my knowledge, that has never happened in the history of these organizations or the history of New Hampshire. We have no knowledge whatsoever that any of these bodies ever will issue some kind of mandate on the good folks of our state, nor would such a mandate, if dreamed up by any of these organizations, have any effect of force or law in our state. So it would not be worth the paper it's written on if some bureaucrat somewhere in Zurich or Upper East Side of New York, because I think that's where the UN is, decided to write some sheet of paper. So because this bill literally does not change any past practice, will not change any future practice, I see no reason that we should enact this legislation.
Sorry, Representative Perez.
I am very sure that the 23 million African men never thought it would happen to them either.
All right. Anyone else wish to be heard on the vote on the main bill with the two amendments? Seeing none, I would ask the clerk to call the roll on ought to pass on HB 584 as with the two amendments that we've previously voted on.
Vice Chairman Mannion.
Yes.
Representative Alexander.
Yes.
Representative Tripp.
Yes.
Representative Andrews.
Yes.
Representative Kutab.
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland.
Yes.
Representative C.
Yes.
Representative Smith. Representative Horrigan.
No.
Representative Birch.
No.
Representative Harvey.
No.
Representative Manos.
No.
Representative Tur.
No.
Representative Rombo.
No.
And Representative Bergeron.
No.
And Chairman Lynn.
Yes.
10 yeas, 8 nays.
All right. And Representative Manning, could I ask you to write the report
Yes.
for the majority? And will there be a minority?
Yes,
Report.
there will definitely be a
All right.
Minority, we want to jump forward.
But I think Representative Smith has already done that.
Oh, okay.
All right. All right.
That will not be on consent.
That will not be on consent, that's for sure. All right, so we've done 584. All right, hang on one second. Allowance. Consent decrees. All right, I think, this is,
I think they want to talk about
Yeah. No. So I'm going to take, I'm going to take I'm going to recess the executive session now for, let's say, 30 minutes, so that people can, do whatever they need to do, including eating lunch or other things, and also to have, if some people need to caucus, they can caucus. Thank you, and thank you, Representative C, for being here. I know you have, this has been an inconvenience for you, and I appreciate it very much. Thank you. Have we got everybody back? Oh, well, not quite.
People coming back. That's very generous. Very nice.
So,
I don't know you, but
they, you know what's up?
Yeah.
All right, so I'm going to reconvene the executive session of the Judiciary Committee, and I'm going to, as the next bill to take up to exec, is HB 580 FN, and the chair recognizes Representative Smith or her designee for a motion.
Mr. Chair, on 580, I recommend retain.
All right, is there a second for that? All right, hang on. So it's moved by Representative Smith, seconded by Representative Rombo. All right, Representative Smith, do you wish to speak to your motion?
I think the issues that are raised in this bill are very serious. I think that the structure of the bill does not completely address those issues. And I believe that if the committee takes seriously its role and will spend some time trying to improve the bill, we could end up with a product that meets majority agreement.
All right, anyone else wish to be heard on the motion to retain on House Bill 580? All right, so I agree to say basically I'm in agreement with Representative Smith. I have at least one idea, as I mentioned earlier, about a possible resolution that may or may not be, something that would draw majority support from everybody on the committee. But it's something. I mean, that demonstrates to me that it's at least worth thinking about. So I would support the motion to retain. Anyone else wish to be heard on the motion to retain on House Bill 580? All right, seeing none, I'd ask the clerk to call the roll, please. The motion is to retain.
Vice Chairman Mannion.
Yes.
Representative Alexander.
Yes.
Representative Tripp. Representative Andrews.
Yes.
Representative Kutab.
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland.
Yes.
Representative C.
Yes.
Representative Smith.
Yes.
Representative Horgan.
Yes.
Representative Birch.
Yes.
Representative Harvey.
Yes.
Representative Manos.
Yes.
Representative Tur.
Yes.
Representative Rombo.
Yes.
Representative Bergeron.
Yes. Thank you.
And Chairman Lynn.
Yes.
18 yeas, 0 nays.
All right. So we don't need a report on that. That takes care of 580. Next, I'm going to take up House Bill 132, and the chair recognizes Representative Kuta.
Thank you, Chairman Lynn. I move ought to pass with amendment 2025-0927H.
All right. Is there a second?
I second that.
All right, moved by Representative Kutab, seconded by Representative Alexander. Representative Kutab, do you wish to speak to your motion?
Yes, thank you, Chairman Lynn. This amendment, while we heard a lot of testimony about how kind of archaic this statute is, and that we're not jailing people, I think most of us can agree we should remove that part out if we're not doing it. We wouldn't want it to actually happen. And so that whole chunk of the bill has all been removed. We're no longer jailing people. However, this has been a useful tool, particularly in smaller towns when a relative is capable of providing this means, so that the neighbors aren't having to pick up the tab for something that the family could pay for. But this is also making sure that aid to the person who's otherwise eligible for assistance under this chapter shall not be withheld due to the failure of a legally liable relative to either respond or provide the aid. And I think that is really important. We don't want to have people that need the aid but can't get in touch with a relative not being able to get the aid. However, at the same time, we want to make sure if somebody is able to provide it, that they are providing it. So for that reason, I think it's important to amend the bill with this amendment. Thank you.
All right. Anyone else wish to be heard on, we're talking actually now about the amendment 2025-0927H to House Bill 132. Anyone else wish to be heard?
Yes.
Oh, yes, Representative Birch.
So I'd like to ask, if I may, a clarification, just to make sure I understand the amendment. The idea of this bill as amended would be that the town or city would still provide the aid, but that they could then sue any of the named relatives for the money, go through their finances, subpoena their financial records and tax forms, and do all the rest to see if they could have sufficient means to pay. Is that the idea of this bill amendment?
Thank you for the question. So currently, they are able to do all of that, but they're not really doing all of that. And if they find that you are able and you're just not doing it, they can jail you right now for at least 60 days, but up to 90 days. And so this is removing that jail piece out. So I think it is important to remove that piece out. I do think the welfare officer made it pretty clear that they're not going through the process of doing all of this legwork. But if somebody does come in and says, yeah, I'm able to help that family member out, they're having that family member help out, but they're not subpoenaing people. So it's not happening now. I don't necessarily see it happening in the future. But I do think that it's important that currently they're able to work together to try and get the relatives to help out if they're able to. If we repealed this altogether, then there would be nothing at all, there'd be no reason that a relative would even try to or necessarily want to help if they don't have to, because why pay money that you don't have to pay, right?
No.
Anyone else wish?
I mean, you'd hope somebody doesn't think that way, but.
Anyone else wish to be heard on this? Yes, Representative Bergeron.
I know you've probably already dealt with this, but I was uncomfortable with the word poor just for that reason, but you've had more experience than I have. So it just says that on the bill, and I've noticed it last time and it kind of bothered me a little bit, but I don't know about the word poor. But, if everybody's happy with it, then.
May I? So
Yeah,
that's existing in the current statute. I didn't change that piece in there. I suppose it could be changed to say, in poverty, I think, but I it's already in there. This statute was, pretty old. It came up in the 1900s when it was first kind of put in. So I think, that was just a term that was used at that time, and I didn't go through changing that language.
All right. Other questions? Anyone else wish to be heard? So I guess, what I would say is, first of all, I think that Representative Kutab's amendment makes this law much better than the original version. And my sense, and I don't know whether Representative Birch would agree with me on this or not. I think, and I think this maybe goes to what a little bit about the question you're asking. I think that there could be, in some circumstances, a real question as to the constitutionality of this if, for example, the state or a town were trying to hold someone responsible for providing support or something for, you know, an adult child who didn't live in the home and it was on their own and maybe seriously estranged from the parents or whatever. I don't know about that. Whether there be some constitutional issue with that or not. But I think the other side of that argument is that if such a person is not held liable, then the burden falls on the entire town, and that's a legitimate interest too. I guess what I would say is, it seems to me that this statute has been on the books for a long time. It doesn't appear from the evidence we heard that it's being abused. Towns are handling it, you know, are exercising their discretion appropriately, it seems to me. This, by taking out the language of jail, that seems to me it softens it even further. And so what I would say is, excuse me, I would support this, and my sense would be, if there are some circumstances in which, you know, it would be really unfair to the point of being unconstitutional for a town to try to collect from somebody, then that's a time for that to be challenged, and the court would rule that way. But I don't think that that's a reason not to have this statute in this amended form on the books, because I think it does serve some useful purpose. So I intend to support the amendment and vote for it. And you, Representative Tripp.
Having been a town councilor and having had to deal with this, you know, I am probably going to vote no, because, you know, it appears that this would make the towns and cities liable for all the homeless people that are in there. That's already in the statute?
That's already in statute. That part isn't changing. The part that's changing about it is just the part that's saying that they already have to provide it, but it's saying that if they can't get a hold of the relative, or if the relative refuses to provide it, that the town does still have to provide it. Right now, if you can't get a hold of the relative, technically the town could just refuse to provide the aid. And that has become problematic in some towns because some relatives just don't respond, although the majority of the towns are just giving the aid anyhow. But that liability already exists in the current statute with pretty similar language to this.
Well, I agree with you on that. The issue that I have is that this simply clarifies that the towns are responsible for the homeless people that reside in it, and it'll probably be people taking much more advantage of this. Thank you.
All right. Anyone else want to be heard? All right. So we're on the amendment 0927H, and anybody can I do this by a show of hands, or does anybody want a roll call? All right. So I'll do it by a show of hands. Can I ask all those who are in favor of Amendment 0927H to House Bill 132 FN, please raise your hand. $17. All right. And Representative Tripp is opposed. All right. No, that's fine. 17. Passed. All right. Now we're on to the main motion. Representative Kutov, you move OTPA, is that correct?
Yes.
And is that seconded, Representative Alexander? Seconded by Representative Alexander. All right. Anyone have anything further they want to say on the bill as amended?
Can I bring up one thing?
Yes, Representative Kutov and then Representative Birch.
So I just, to get back to what Rep Tripp was mentioning, what it currently says in the statute is if a poor person has no relation of sufficient ability, the town or city in which he resides shall be reliable for his support. So it's already in current statute that that the town is liable.
Representative Birch.
Thank you. I intend to vote against this. We have OTP, which is to repeat as amended.
Right, as amended, yes.
So I intend to vote against that. To follow up what the representative just said, it seems to me the obligation on the town first would have to be to find out if any relative could pay, and then pay if there is no such relative. So as I understand this bill now, if there's any poor person within the town, the town would then have to start an investigation before paying any support to that person, would have to go then investigate the father, mother, stepfather, stepmother, son, daughter, husband, or wife to determine, and only if they can't, then if there's no relation of sufficient ability, then the town or city, and this is lines 21 and 22, shall be liable for their support. So the order that it's done seems to be set out in the statute, that first you find out if somebody else can do it, and only then will the state have, or the town have an obligation to step forward. I don't like that idea, if I'm correct in it. And the second part is, again, I live in a small town. Pretty much everybody knows everybody. And what we have here is a situation of unbridled discretion on the town or the overseer of the poor, or whatever it's called in any particular town. And I think our town still calls it that. That overseer of the poor has no boundaries on discretion. So he or she is sitting in their office and somebody comes in and the overseer of the poor says, "Oh, I know that family, I'm not going to bother collecting." Or, "I know that family, I'm going to go investigate them more thoroughly and check into their finances of all the relatives." So it's unbridled discretion on behalf of this town official as to who might be subject to this recoupment and who not. I don't think there's no process here to assure that it's being done fairly and equitably, especially in the small towns. In Manchester or Nashua or Concord, that may not be a problem where people are more anonymous. But in small towns, and I represent 3 of them, it's a different issue. Thank you.
Representative Kuta.
Thank you, and thank you for the question. So, right now, what's currently on the books is that they have to do what you mentioned with finding out if they're able, and should they find out if they're able, then if they refuse to do it, they'll be ordered by the county commissioner, selectman, or overseer of public welfare, and if they don't do it, then they'll be summoned to appear before court, and if after a hearing it's found that the alleged person is in need of assistance and that the relative is able to render it, then the court will enter a decree accordingly to demand that the person provide this, and if they don't, then they'll be jailed. So I think what's currently on the books is a lot more, what this is saying is that if the person doesn't answer or refuses to say if they can provide it or not, the town is still going to provide it. If we don't have this at all, then the town is perhaps not going to provide any aid to anybody.
All right. Anyone else wish to be heard? Yes, Representative Bergeron.
If you don't mind, I'd like to ask a sort of a general question after we pass bills like that. Do we ever get data? Or do we only get data if we review the bill again? Or, from the outside folks, like, how's this going? That kind of.
All right. Well, it sort of depends, and I guess, we did get, I think we got some information at the hearing. Anyone else wish to, Representative Tripp?
So I guess that's a no.
I have a question of Representative Katab.
How do we know it's a?
Was there a reason that you removed the county commissioners from the people that were responsible?
Yes, so I did talk to the several of the county commissioners, and none of them had ever done this before. It was all going through the welfare administrator. They were never doing anything like this. The ones that I spoke with.
Thank you.
Right, Representative Horgan.
Another related question. What if this is probably a fairly rare thing, but what about the case where the person lives in a unincorporated place, in which case then the county commissioners basically serve as the select board for that portion of the county that's not part of an incorporated town. So, of which there's one town in Carroll County and several, which has some population, and then there's one township in Carroll County, and then there's several in Coas County. One that's uninhabited in Grafton too. But
I believe overall we have one welfare administrator for the state who came here to testify before us. And so he assists the cities and towns with this type of a thing. So I think they would, even if they're an unincorporated place, they would still be able to use that paid administrator from the state.
okay, sure. Yep, sounds.
All right, any further comments? So the only comment I would make in response to Representative Birch is, I mean, your scenario about like they're going to investigate somebody that might be potentially liable and do discovery and all that. I mean, it seems to me that there was no evidence to suggest that that kind of thing had happened with the existing law, which is considerably more onerous, carrying the potential of jail than the proposed amendment. So, theoretically, could that happen? I suppose it's possible, but it seems to me that it's no more likely to happen with this amendment than it is under existing law, and it seems like it doesn't happen. So, I think that I'm sort of satisfied with that. Representative Birch.
Respectfully, it'll never happen if we defeat the OTPA and vote ITL. Then we don't have to worry about whether it'll happen or not, because it won't. Thank you.
All right. Any further comment? All right. So we've already voted on the amendment 17-1 to pass. This is now a motion of vote on the main bill with the amendment, OTPA. So I'd ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Representative Alexander,
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland,
Yes.
Representative C,
Yes.
Representative Smith, Representative Horrigan,
No.
Representative Birch,
No.
Representative Page. Oh, sorry. Representative Harvey.
No.
Representative Manos.
Yes.
Was that a yes? Representative Tur.
Yes.
Representative Rombo.
No.
Representative Bergeron.
Yes.
And Chairman Lynn.
Yes.
13 yeas, 5 nays.
All right. Representative Kutab, could I ask you to write the majority report?
I'd be happy to.
All right. Now, will there be a minority report?
Sure. No.
All
Somebody else want to write it? Pardon?
have to have it. But if you want one, sure.
Give me a moment. All right, I'll skip it.
All right. No minority report. Okay. No All right. This is a regular calendar, yeah. All right. All right, next, so that takes care of 132. Next, I'm going to, I'm going to turn to House Bill 188, and I'm going to recognize myself, and I move to pass House Bill 188. Is there a second?
I second that.
Seconded, moved by myself, seconded by Representative Alexander. And so I'm gonna, this is a little bit, maybe a little bit unusual, but I know you have an amendment, Representative Manos. I'm not inclined to take up that amendment, but I do want to give you an opportunity to just tell, as I understand it, the amendment changes the Superior Court to the Circuit Court. So in the interest of sort of having a discussion, tell us why you think that.
Well, Mr. Chair, to be fair, you have to entertain an amendment if it's a not to pass motion. She can move her amendment if she wants.
Yes, I do want.
She can call for a vote on the amendment.
I see what you're saying. Okay, all right. So, all right. So I guess then I'll recognize you then. Do you move amendment?
0921H.
0921H. All right.
Very briefly, Mr. Chair, thank you.
First of all, is there a second for that?
Oh, excuse me.
I'll second.
All right. So moved by Representative Manos, seconded by Representative Perez. Go ahead, Representative Manos.
Thank you, Mr. Chair. Very briefly, my amendment does align the misdemeanor offense here, both criminal and the criminal offense of misdemeanor, with it being in the circuit court. So that's what it does. It also takes out all the references to committees, subcommittees, joint committees. I'm not sure that OLS drafted this in a way that we can easily see that, but it does do that. And so those are the two changes that it makes to the underlying bill. I've got one. I don't know where it is. Here it is.
Can I speak to that as well?
So you're speaking to Representative Manos's amendment?
Yes.
Yes. Go ahead, please.
I just circulated around another amendment, which is not what we're talking about at the moment. These were supposed to be two separate amendments, but Representative Manos incorporated mine into hers. So I just kind of wanted to make it clear that there are two separate concepts on the table, one of them related to the courts, one of them related to some extraneous language that was included about other entities that I believe from your testimony, Mr. Chair, might have been incorporated from federal language, but that those entities do not have the ability to make or to issue subpoenas. So I took those pieces out to clear up the language. So if you favor Representative Manos's, I did check, and it looks like it's her amendment is the same as what would be there, plus the change in the courts. And if that does not go, then I might speak to my amendment.
All right. Anyone else wish to be heard? All right. So I guess what I'd say is I have two things on that. First, with regard to which court, as I think I mentioned at the hearing, I deliberately chose the Superior Court because it's a constitutional court. It seems to me that this would be the kind of proceeding that ought to go to the Superior Court if you're going to, if the legislature asking the judicial branch to find somebody in contempt, send them potentially, find them guilty of a crime, or send them potentially to jail until they comply. it seems to me that this is the kind of thing that ought to go to the constitutional trial court, not the circuit court. More importantly, to the extent that this calls for the issuance of an injunction to compel somebody to comply on pain of being held in contempt, generally the circuit court doesn't have equity jurisdiction to issue injunctions. Now, it's true that in marital cases and something like that, they do issue injunctions. So it's not an absolute hard and fast rule, but it seems to me that allowing this to go to the circuit court, the other thing would be, and especially if it's a criminal case, it's a misdemeanor. The state could charge it as a Class A misdemeanor, which would mean there would be a right to a jury trial. The circuit court doesn't do jury trials. So for all of those reasons, I think having this proceeding in the superior court is the right thing to do. With regard to the language about the joint committees and things like that, I think that it's important to keep that language in there because the way it's worded in the original bill, I think the important language there is comply with a subpoena duly issued and served. So all of that means that whatever the entity, whether it's a House committee or a Senate committee or a joint committee, and those are the three I think that are covered by the language of the original bill, those committees would have to have have been granted by rule the authority to issue subpoenas. So I don't think that language is extraneous. I did take it from the federal statute, but I think that could easily apply. I mean, it seems to me the House and the Senate by rule could authorize a joint committee to conduct an investigation and give that joint committee subpoena power. So, Representative Turr.
Yeah, just on that part, and just to explain a little bit further, I did look at the rules of both the House and the Senate. They're separate rule sets. There's no provisions in either one of them for referring to the other body, and the power to issue it is not granted to the committees. It's only granted to the leader of either of those bodies. And so I feel like leaving that language in there suggests, although obviously there'd be no way to operationalize that language, it seems to suggest that there is the authority, and I believe that's what started this whole question to begin with last year, was a committee sort of asserting the ability to issue a subpoena that they were not authorized to do. So, I hope you don't, again, be it through this amendment or maybe through my second amendment, if not, agree that taking it out would be cleaner than leaving it in, because whatever House rules, and they can change, as long as we say duly authorized, we're incorporating both bodies' rules without having to potentially run into conflicts in the future.
Sure. Yeah. All right, Representative Manos. Yeah, sorry, Representative Mannion. I apologize.
So my understanding, or this is my interpretation of that, the subpoena is being issued and served by either house, like the rules say. The purpose of it is under an inquiry before either the whole house or any joint committee established by a joint or concurrent resolution of the two houses. It just covers the areas of where the subpoena is, where the inquiry is coming from, a committee or a joint committee. It doesn't change the fact that the subpoena is coming from the House, the Speaker of the House, like the rules say. So I see it as just the opposite of what you're saying. This is just telling you where the inquiry is coming from, and the only person that can issue it and serve it is the House of the General Court, either house, being the Speaker or the President.
All I'll say is that the rules change with each House session, so I think it's cleaner not to have it, but understand what you're saying.
Yeah, see, I guess my concern is I think it's actually cleaner to have it in there, because it covers then all situations. I mean, I would not want to have potentially a situation, suppose that the House and the Senate decided in some year that they were going to authorize a joint investigation to be conducted by the two bodies, and they were going to authorize that body, that joint committee to have the power of issuing subpoenas. I think under the language of the bill as I drafted it, that would then be a duly authorized issued subpoena, but I'm not sure that it would be under, I mean, at least an argument could be made, well, maybe that's not one that's authorized under your language. That's my only concern. So that's why I think the broader language. And as I said, with regard to the circuit or superior court, I think I've already stated my reasons. So I guess Representative Turr does Representative Manos's amendment encompass the things that, I mean, does it encompass your amendment? Do we have to vote separately on both of them, or just Representative Manos?
Well, if you don't support Representative Manos's amendment, then I would wonder if you would consider mine without the change in the court system. But
okay.
Otherwise, I did a quick read, and I did send everyone a markup by email showing what I took out. But I believe Representative Manos's amendment incorporates mine as well.
All right. Well, so let's see where we go on the Manos amendment, and then if that fails, I'll turn to yours. So I just to sum up, I plan to vote against the Manos amendment for the reasons I've just stated. Anyone else have anything they want to say? All right. So the motion is on Representative Manos's amendment, which is 0921H. And do we need anybody want a roll call, or can we do this by show of hands? All right, so all those in favor of Representative Manos's amendment 0921H, please raise your hand. 3, 4. All right, hang on. All right, and all those opposed to Representative Manos' amendment, please raise your hand. 1, 10, 11. 11. All right, 4 to 11, so the amendment fails. Wait a minute. Oh, somebody didn't vote. Oh, wait a minute. Oh, wait a minute. Let's try again. All those in favor of Representative Manos' amendment, please raise your hand. 1, 2, 3, 4. All right. Now, all those opposed to Representative Manos' amendment, please raise your hand. 1, 2, 3, 4. 14. All right. I've learned to count now. 14 to 4, the amendment fails. All right. Let me turn then to, hang on, this is 0921. Yeah, I recognize Representative Turr, and do you want to speak to anything further you want to say about your amendment?
Yes, to introduce it.
Yeah, just to introduce it, it's 2025-0944H, and I think I've said all I can about why.
All right, is there a second for Representative Turr's motion? All right, moved by, excuse me, Representative Turr, seconded by Representative Manos. All right, anyone else wish to speak to Representative Turr's amendment? Yeah. I mean, I think it basically, I do think I understand what it does. So, all right. And for the reasons I've stated before, I think that the language should stay as in the original bill for the reasons I've stated. Anyone else want to speak on Representative Tur's amendment. All right, then can I ask for a show of hands, all of those in favor of Representative Tur's amendment 0944H, please raise your hand. 1, 2, 3, 4, 5, 6, 7. All right. 7. And those opposed to Representative Tur's amendment, please raise your hand. 2, 3, 6, 8, 9, 10. Wait a minute, we got,
If the number was not right, I raised my hand late in favor of.
all right, wait a minute, let me start again. All those in favor of Representative Tur's amendment, please raise your hand. No, in favor of Representative Tur's amendment. Oh, 1, 2, 3, 4, 5, 6, 7, 8. All right, 8. Sorry. All right. Now, all those opposed to Representative Tur's amendment, please raise your hand. 2, 3, 4, 5, 6, 7, 8, 9, 10. All right. 8 to 10, the amendment fails. All right. Now we're back to the main motion. I would move ought to pass on HB 188 as drafted. Is there a second? Seconded by Representative Alexander. All right. Second. All right. Anybody have anything else they want to say on the motion of OTP on 188? Seeing none, I've asked the clerk to call the roll, please.
Vice Chairman Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews. Yes. Representative Kutab,
Yes.
Representative Perez. Yes. Clerk votes yes. Representative McFarland,
Yes.
Representative C,
Yes.
Representative Smith. Yes. Representative Horrigan,
Yes.
Representative Birch,
Yes.
Representative Harvey,
Yes.
Representative Manos,
Yes.
Representative Tur,
Yes.
Representative Rombo,
Yes.
Representative Bergeron,
Yes. Thank you.
and Chairman Lynn.
Yes.
18 yeas, 0 nays.
All right. Can that go on consent? All right, consent, and I will write the report. All right. And that takes care of.
So who's writing the report?
I'm
You are?
writing. Next, I'd like to turn to, hang on one second, I just want to keep all this paperwork in order here. So I have my Bible here. All right, next, I'm going to turn to House Bill 687, relative to class action settlements and consent decrees. And I'm going to recognize myself and move ought to pass. Is there a second? Representative Kutab?
I second.
Hang on. All right. 687. Hang on while I find this. 687. 188. Over here. So I basically, what this bill provides is that class action, if there's money that's not to be distributed to class members, then it sheets to the state, and that the doctrine of cypre shall not apply to allow courts to allow monies that are not distributed to class members to be diverted, and I know that might, some people might say maybe diverted is the wrong word, but changed to another purpose. I think that makes sense. The bill also would provide that attorneys' fees awards in consent decrees are limited to that as provided in the LAF fee matrix. And if the bill was limited to saying that, I would have some problems with it, but it says unless the court otherwise determines. So the court would have discretion to find that some other method of awarding attorney's fees was appropriate. And I think as long as the court has that discretion, I don't have any problem with that. So for those reasons, I would support the bill. I intend to vote in favor of it. Anyone else wish to be heard on 687? Representative Birch.
Thank you, Mr. Chair. What troubles me about this bill is I get that mail from time to time that there's a class action filed and please return the proper forms, and you might get your $4.23 out of the class action. I'm sure most of us have gotten those. These tend to be nationwide, multi-jurisdictional lawsuits. Often large corporations have done something wrong and they need to refund some, or they're being sued and they might have to refund some money. It makes little sense to me for New Hampshire to create its own system for distribution of money and the like, which may be in conflict with what's happening in maybe 49 or however many states are being affected by this class action suit. So all of a sudden, whoever is disgorging this money, whether it's the court somewhere in Omaha or somewhere else, wherever they're disgorging it, is going to have to pay attention to HB 687 separately, and the like. And I know it's just talking about money that's otherwise not distributed, but this might work well to me in a class action that's solely New Hampshire. But I don't see, maybe I've just missed it, that this applies to all class actions that affect the citizens of New Hampshire, and I just don't see it's workable.
All right. Anyone else wish to be heard? So I think my response to that, Representative Birchwood, it seems to me that it would only apply to class actions that New Hampshire has jurisdiction over. And it would seem to me that if there was a nationwide class action, let's say that was in federal court or in the court of some other state, I would assume that the how proceeds should be distributed would be determined by the court of that state or the federal court, and New Hampshire wouldn't have any jurisdiction. So that's the way I would interpret it.
It would be nice if it said it.
Well, I don't think it. I'm not sure that if it does, that by not saying it, that would give New Hampshire some jurisdiction where it wouldn't otherwise have jurisdiction. So, anyone? Yes, Representative Horgan.
It gives no definition of what the Laffey matrix is, and I never heard of it until this bill came along. But apparently there are several different versions of it, and there's other matrices used in other jurisdictions. Apparently, only originated in the Washington D.C. Baltimore metro area. So that seems like a pretty glaring weakness with the bill that relies on something that it doesn't say exactly what it is. So.
Yeah.
Yes, Representative Birch.
If I could just go a little further on that. Yes, the Laffey matrix has been rejected by numerous courts. And there's even a Laffey matrix 2, which has also been rejected by numerous federal courts. Though I think the Baltimore-Washington jurisdiction around there is one that still does it. Why we would be promoting or suggesting or having that as the option of first course, I don't know, given how rejected it's been.
So I guess my only response to that would be if as I said before, if there wasn't the unless language in there, I might be concerned about that. But since the New Hampshire courts, I think, are fully capable of determining whether, it makes sense in a particular case or not, I assume they would do that. So anyway, anybody have anything further they want to say on HB 687? I'm seeing none. The motion is OTP on 687, and I'd ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland,
Yes.
Representative C,
Yes.
Representative Smith, Representative Horrigan,
No.
Representative Birch,
No.
Representative Harvey,
No.
Representative Manos,
No.
Representative Tur,
No.
Representative Rombo,
No.
Representative Bergeron,
No, thanks. No, thank you.
and Represent Chairman Lynn.
Yes.
10 yeas, 8 nays.
I'll write the main report. Is it going to be a minority report?
I'm not doing it. I can tell you that.
Paul's gonna be busy.
Anybody want to write a minority report? Don't have to. You don't have to, but
All right, I'll write one.
all right. Birch. Yes, minority.
It's gonna be short.
So that takes care of 687. All right. Next, I'm going to turn to, hang on. House Bill 722, and the chair recognizes Representative McFarland.
Thank you, Mr. Chairman. I move that we adopt the amendment 20250965H.
So you move the bill and you move this
Yeah,
amendment.
ought
is
to
that
pass
correct?
with amendment.
All right. Is there a second for this? All right. Seconded, moved by Representative McFarland, seconded by Representative Alexander. And Representative McFarland, do you wish to speak to the amendment?
Yes, I would be pleased to. So the amendment, which I know you have in front of you, I have provided one page that is a sample disclaimer in 24-point font, which I'll come back to. And then I've provided you with the amendment. This addresses, I believe, the vast majority of the concerns that had been expressed relative to the prime sponsor's original language. And so what I would talk about is really just let's focus on the amended bill. New Hampshire students deserve transparency when making one of the biggest financial decisions of their lives. Investing in a college degree is something that comes with significant costs and risks, and indeed opportunity costs that are lost versus what else they could be getting up to. And so when we examine the circumstances, we see that prospective students are often unaware or regretful about the true costs and those financial risks of higher education. And so what we need to do is we need to make sure that we're giving them the context, that we're giving them enough information that they can make a free market decision as to whether they want to enter into that degree program, and make sure that they understand what they're putting themselves down for. And so the amended bill, it requires either that the educational institution provides certain disclosures, or that if the educational institution does not wish to do that, that they get the prospective student upon matriculation to sign off on a disclaimer. That's it, right? If I am a company wanting to engage in the business of higher education and I say, well, I don't believe I should be regulated this heavily, then you just need to get the student, along with signing the other 37 pieces of paper when they sign up, to sign that piece of paper as well. But if you do want to offer your prospective students some strong information that may be helpful to them in the marketplace, this bill lays out a number of items that we would like to see in there. And in particular, what it does is it helps them understand how much they are likely to make, whether they're likely to graduate, whether they're likely to be successful, and gives them the opportunity to contemplate options. And it also identifies to them something that I've come across plenty of students that still to this day don't understand, and that is that with the changes in federal law that we have seen, a lot of these student loans are not dischargeable in bankruptcy. So either way, whether the educational institution chooses to provide the information or whether they don't, that fact is going to become abundantly clear to the student who's signing up. So I think beyond that, I would be happy to answer any questions, but I just encourage you to move or to pass.
All right. Representative Smith and then Representative Ward.
Thank you. I do have a few questions until the chair stops me. I notice, Representative, that all of this refers to the students. Does any of it refer to the people who, in fact, are signing the checks, which is most likely the parents?
So first off, the answer is it does refer to the students, right? The purpose of this bill is less about presenting a cause of action for whether it's students or whomever than Travis's original bill was. This bill is now about transparency and disclosure. So at one level, you could say that that aspect of it is less material. But I would also say that at the end of the day, entering into a degree program is a decision that should be made on an informed basis by the student themselves, and they should not be being pushed into it by anyone, including their parents or their guardians or whoever may be paying their bills. And I think when you look at the entrepreneurship that we want to encourage in this country, what you see a lot of times with college graduates is you see grads who are having on a regular, recurring monthly basis to pay a certain nut to pay off their loans, and are not able to just stop doing that so that they can contemplate starting up a small business or doing something else entrepreneurial. So I think to your question, Representative Smith, I would suggest that the most important person in that decision is the student themselves.
Could I follow up?
Yes, absolutely.
There's nothing that I said that didn't recognize that. But when you're talking about financial matters, the writing of the check, I believe, is rather important, and the implications of that, I'm curious that you don't seem to think that the check writers should have that information, that it should only be the student.
Oh, I see. Okay, so two quick responses to that, because I think it breaks down in two parts, right? One is, as far as the information goes, they would have that. If the educational institution chooses to comply with the disclosure requirements in here, then that includes publishing it on a website for anyone to see, not just for the prospective students. So that's the first part of the answer. And I think the second part of the answer is that to the extent that there's a desire to go after them in court, the fact that the parents, for example, may have paid for the degree, they are paying for that on behalf of the student for the benefit of the student, and it's still the student who is harmed if they are going through a degree program that does not actually deliver on the promises.
Could I ask one more, and then I'll abandon the field for at least a while? Let's just think about the people who are the students who are in college today and have decided on a major, a focus of their college education today, and are pursuing that at the cost that they incur. Of those students who are in college today and have chosen what they want to specialize in, how many of those students in 5 years will find that those particular foci, the plural of focus in this case, are still relevant, or that particular focus has gone the way of the platypus and now they're doing something else?
So I don't have quantitative statistics on that in front of me, but I would say to you anecdotally that first of all, what we see in the marketplace is typically that, yes, people may end up pursuing a course of employment which is not 100% aligned to their chosen major. However, I think we can more commonly see patterns in who is successful in the marketplace, in the workplace, and what their major is. And so, I think we can certainly anticipate that there are going to be different outcomes for a similar quality student pursuing an underborder basket weaving degree than pursuing, let's say, a law degree or a medicine degree.
Could I just ask one more, and that is the sole purpose of higher education vocational training, or are there any other benefits that
great
come?
question. I mean, the answer is really easy. Absolutely not. But if you are somebody who is contemplating higher education for other purposes than to provide for yourself, you are perfectly at liberty to then either look at the disclosed information and ignore it, or sign the disclaimer, and you're in a happy position, and I wish those students well. I do, however, think that there are too many students today who are not in that fortunate position to be able to study purely for other reasons than employment, who are occasioned to enter into degree programs for which they are not best suited, or which are not best suited to give them the skills for their later life.
Thank you.
Other Representative Ward.
Well, we heard the cliche about basket weaving, and actually some basket weavers make good money, but there aren't many openings at the top of the basket weaving industry. But
yes, that's why I refer to median earnings.
Yes, and of course, then you get the we got a letter from the Director of Government Relations for the University System of New Hampshire, and I'm probably the only one who printed it up and was then able to find my copy of it. But where, first of all, they don't have the earnings data for all of their graduates. They would have to get it from the IRS, although UNH and most universities, colleges do make an effort to keep track of their students. So I'll get to that later, that they do. But so the first, and so then they're going to say there is a program called the Financial Value Transparency and Gainful Employment Regime, FVTGE, and that's been apparently in the works for several years. And unfortunately, that program is run by the IRS, and I'm not sure what's happening with the IRS agents, but I think a lot of them have been slashed with the chainsaw, and the Department of Education, which theoretically has been dismantled. So you've got at least an agency that's supposed, at least ostensibly, is non-existent, running this program that we're relying on. And so that's one problem. This data, the only data source we have to work on is one we can't really rely on existing in the future. But So that's one problem with it. And we're trying to punish the educational institutions for decisions, individual decisions made by the students, and some of those work out better than others. Some people make good money out of basket weaving. Some people go into law and medicine and don't do so well. It has to do a lot with the individuals more than the choice of degree. But then on the other hand, we're talking about the marketplace, colleges, universities, the major ones like UNH or or the ones I went to. They make a lot of effort to try to keep track of their graduates, to encourage them to network, encourage them to earn more money, and encourage them to be as generous as possible in the future after they get their degree with their earnings. So these institutions do, I believe, have a vested interest in trying to maximize the earnings potential of their graduates even after they graduate. So it's not just they take the tuitions and fees and then ignore them for the next years of their life, because most people graduate when they're about 22, so they have about they've got like many decades of life ahead of them. So I would probably I'd probably say we can probably actually rely on the marketplace for them to prepare people for life. And as I said, it's hard to tell which degrees work out well. As I said, some people, if you're very good at basket weaving, you can actually make good money out of basket weaving. It's probably harder than law or medicine, and plenty of people go into law or medicine or whatever, and they fail at it. So,
All right, great. Representative Tur.
Yeah, thank you, Mr. Chair. So, I look at this amendment, and I know I don't get to probably raise questions of whether it's totally germane or not, but, this feels very different than the bill that I read. The original bill didn't allow you to make a free market decision about the value of education. It more or less told you what a good value was or wasn't and sort of made you sign waivers. This seems to implement a whole completely different scheme around how information would be compiled, how it would be shared, what it would contain, sort of using, retrospective data to make prospective judgments. And I guess I would say I find it kind of surprising that this is kind of just an amendment to the original bill. This could have a whole hearing all by itself. In my mind, I can think of a whole bunch of questions that I would have asked here. So I don't know whether or not something other than passing this would be possible, but it seems like this needs a lot more consideration than sort of an amendment that we all just looked at.
All right, Representative Birch, sorry.
I would just start off as a preliminary matter in response to what Representative Tur said, and it's not directed against the representative filed this. I have a general policy problem with filing complete rewrites of bills at the executive, at the exec session, and not having any input by the public, no fiscal note, which this thing clearly would require a major fiscal note because the impact on the schools, universities, and colleges in New Hampshire would be massive. And then we have nobody with specific expertise to ask the particular questions of. So that's a general objection. It's not just specific to this bill. But I want to ask a question or two about, on page 3, the return of on investment section, that the institution shall be required to estimate the median salary outcomes of some college student who comes in not knowing what he or she wants to do, perhaps doesn't even know what their major will be, and yet the school will be responsible for, in writing, estimating their median salary over time. And then further, the school would be required to indicate by example the characteristics of students who should be expected to earn more or earn less, more or less. And I think of when I went to law school, and the particular law school that I went to, graduated a number of graduates to very high-end law firms, and graduated probably an equal number to teaching profession. And I don't know how a school, law school or otherwise, I'm just using that as an example, would be able to predict for who would be more successful at the beginning in earning this amount of money versus earning that amount of money, and then provide objective guidance to which kind of student will do better in teaching and which will do better in a high-end law firm. And I just think this is a trap for universities and colleges, and an open invitation for lawsuit after lawsuit from individuals who have nothing better to do than try their luck at getting 50% of their educational money back at open-ended cost to the taxpayers. So do you have a thought about that?
Representative McFarland.
Thank you, Mr. Chairman. To Representative Horrigan's points, and I do have the same copy of the University System of New Hampshire's comments on the original bill in front of me, I would say, first of all, that the FETGE Act and the work that the IRS is doing and that the U.S. Department of Education is doing does go some way in this direction. And you bring up a very good point that if we have an expectation that some of those institutions may be reduced in size and scope, then it's all the more reason why we should be wishing to pass this bill. And the other point that I would make, I won't go back into the conversation about what types of degree, but I will say that to the point that you raised around the availability of some of this data that is called for, I've actually included a clause that provides where data is unavailable, that does not stop them from fulfilling the terms of the required data here, as long as they disclose that fact. To Representative Tura's point about whether it's germane or not, I will say that I was at pains to ensure that it is germane precisely by sticking only to the precise structure and topics of the original bill. And I defer to the chairman as to whether we need to get into a debate on that. And finally, I would answer Representative Birch by observing that while we can have a prolonged debate over the points you bring up, at the end of the day, there is no incumbency on these educational institutions to spend any money at all on this. They can simply choose to have the matriculating students sign off on the disclosure statement, on the disclaimer statement. On the other hand, some of those institutions may view this as an excellent competitive opportunity to put their best foot forward and provide information. And you ask about return on investment, and I say to you that the information that is asked for there is not to look into a crystal ball. It is to look at hard facts and statistics and provide indication as to median outcomes and typical details. So if they feel that they can do that, great. And if they don't, they can just have them sign off on a piece of paper.
All right. Anyone else? Whoop. Yes.
Thank you, Mr. Chair. I have a couple questions surrounding this return on investment as well. It just seems unclear to me how any kind of educational institution is going to be able to give a clear picture of return on investment when there's so many outstanding questions that they don't know. For instance, I went to school in Pennsylvania, but here I am in New Hampshire. So, where I live then affects how much money I am going to be paid. I was a teacher. It also doesn't take into consideration whether you're working in private industry or public industry. One's usually paid more than the other. And as far as the disclaimer goes, if that's the answer to everything, well, then just sign the disclaimer. Then I'm curious as to why we need the bill. Not to mention that it's 4 pages long, and I don't read that quickly legalese. So,
All right. Anyone else wish to be heard? Representative Petterno.
Thank you, Mr. Chairman. I would just like to make a quick point that on line 27 on the first page of the amendment and on line 16 on the first page of the underlying bill, any educational institution seems to imply public or private institutions, and I don't believe we have any jurisdiction or authority over private institutions of higher learning. So to begin with, we would have to amend that.
All right. Anyone else wish to be heard? So I guess just the only comment I would make is Representative McFarland, I'm very sympathetic to what you're trying to get at. I really am. But I guess from my general philosophical perspective, I do still think that the doctrine of caveat emptor means something, and I'm really concerned that this is, at least to some extent, there's a certain nanny state feel to this that I just don't, I can't go along with. So although I understand what you're trying to get at, I'm sympathetic to some of the things that sort of outrageous charges that some schools are making. I cannot. For those reasons, I cannot support the amendment. Anyone else wish to be heard on the amendment? All right, so anybody, I would propose to have a raise of hand on the amendment unless anybody objects to that. All right, I've seen no objection. So I say all those in favor of Representative McFarland's amendment, which is number 2025-0965H, please raise your hand. 3. All right, hang on.
4.
Whoop, 4. I'm sorry.
Raise your hands
Raise your hands again, please. If you're in favor of the amendment. Okay. 1, 2, 3. All right. 3. All right. So 3 in favor. If you're opposed to the amendment, please raise your hand. 1, 2. Whoops. 1, 2, 3, 4. 15. 15. All right. All right. So the amendment fails. 15. 3 to 15. All right. So now we're back to the main bill, and the chair recognizes Representative Smith or your designee for a motion.
Yeah,
I'm sorry. do we need
Mr.
to-
Chair, I think Representative McFarland has to withdraw his OTP
Oh, I'm
before you
sorry.
can entertain.
Okay. So that's a good. I mean, you.
Thank you, Mr. Chairman. So I withdraw my motion to OTP the bill and make a motion to retain the bill.
All right. Is there a second for the motion to retain? Seeing none, the motion fails. Hang on 1 second. All right. So now we're on to, is there another motion from Representative Tur?
I'd like to move ITL.
All right. So, Representative Tur moves ITL. Is there a second? Seconded by Representative Manos. All right. ITL. Tur. Second, Manos. All right, Representative Tur, you don't need to say anything further unless you want to, but if you want to, we're all ears.
I do not.
All right. All right, anybody else wish to be heard on the motion of ITL on House Bill 722?
I'd like to make one very brief comment, and that is, I would like to know at some point when we don't have to violate privacy, where in fact our colleague Representative McFarland was educated, because clearly the ROI is very high. Thank you.
All right. Any further comments? All right, then I'd ask the clerk to please call the roll on House Bill 722. The motion before us is inexpedient to legislate.
Vice Chairman Mannion,
Yes.
Representative Alexander.
No.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez.
No.
Clerk votes yes. Representative McFarland,
Yes.
Representative C,
Yes.
Representative Smith,
Yes.
Representative Horrigan,
Yes.
Representative Birch,
Yes.
Representative Harvey,
Yes.
Representative Manos,
Yes.
Representative Tur,
Yes.
Representative Rombo,
Yes.
Representative Bergeron,
Yes.
and Chairman Lynn.
Yes.
Chairman, may I check?
Hang on.
I
Just wait. We're just kind of in the voting mode. Yeah, I'll let you make your comment, but let's wait until we finish voting. What's the vote?
16 yeas, 2 nays.
Oh, did you wish to change your vote? Is that what you're?
that's what I was contemplating based on, but I'm going to refrain from that. Thank
All
you.
right. So it's the vote stays as 16-2. Is that it?
Yes.
16-2. OC. All right. So Representative Tur, since you made the motion, it looks like it's your report to write. Will there be a minority report?
Yeah, I'm okay with consent.
All right. Anybody have a problem with consent? All right. So consent. Representative Turl will write the report. All right. No minority report. No. All right. So we have that takes care of 722. We have 2 bills left. 195 and 522. They are in some sense related. So with regard to HB 195, I'm going to recognize myself, and I will make a motion of OTP A with, hang on. Yeah, so I make a motion of OTPA, and the amendment that I offer, which you all should have, is 2025-0890H. Is there a second, Representative Smith?
Apparently, Representative Smith is seconding it.
Thank you. All right. If I could briefly speak to this motion, oops, I'm gonna find it now. So this bill, as you may recall, this bill is a bill that was passed by the House last year. It died in the Senate. There are a few changes, but that really resulted from the discussions that came up at the hearing. Oh, I'm on 195 with amendment 0890H. 0890H.
I only have 0891.
Oh, wait a minute, now, hold it, did I?
That's correct.
That's right.
0890H? 0890H.
Okay, okay, I'm sorry. I can only find 0891.
Wait a minute,
Okay, I'll find it.
is 0891, doesn't have it?
I hear it. I have it.
Okay.
No, that 0890 is 195.
Right, that's what we're talking about,
Oh,
195.
okay.
We're talking about 195. So you know, Representative, I'm sorry, can I just ask you, when you say 0891, is that also related to 195? Because I want to make sure.
No,
I'm not
that's
confused.
522.
Oh, okay, all right. So is the amendment to House Bill 195. And it makes a few changes in language that were discussed at the hearing and some discussions after the hearing. For example, it adds on page 1 of the amendment on line 28, it adds the language unless specifically authorized by law. I believe that were one of the people that either testified at the hearing or spoke with us or me afterwards, said that language was important to for their interest, to make sure that if there was another authorization, another law that authorized something, it would be all right. On page 2, on line 8, there is a new subdivision E added as another sort of exception, and that was, again, suggested by former Representative Kirk. I think a very good suggestion. It said, look, he basically said, look, there may be sometimes when a third-party provider of information or services needs to make some disclosure to another entity, I guess, for example, might be a credit card company or something, in order to provide the service that the person has asked for. That obviously should be covered. Let me see if there's any. The language, I'm going to turn then to page 3, and you'll see that there is, I changed the language in both Roman numeral 2, and I'll specifically refer you to lines 8 through 11. You'll see that the language now reads, provided, however, that no such notice shall be given if the government entity seeking the information requests that such notice not be provided and demonstrates good cause for making such request, or a court has issued an order that such notice not be given. And I think that's, it just seems that language made more sense. That even if the way it was worded before arguably could be read that unless there was a statute or something like that allowed another statute, that would mean, that allowed the government agency to require that a respondent not disclose information, then they couldn't do it. It seems to me that it makes more sense to say that they have to demonstrate good cause, and if they can't demonstrate good cause, then the provider will notify whoever is the subject of the subpoena. And the same thing applies in line in Roman numeral 3 at lines 16 through 19. Let me see if there's any other changes. No, I think that's really it. I guess I would say I think the changes that were made I don't want to characterize them as not being substantive. I think they are to the extent I've sort of mentioned it. But in terms of, do any of them make a major change to the bill? I don't think they do. And I think the bill still makes great sense for the same reason it made sense last year. I'm sorry. Most important thing in paragraph on page 1, lines 8 through 10, the definition of available to the public is changed to read available to the public, which means personal information about an individual which is widely known or readily accessible to the public, and in which an individual could not have a reasonable expectation of privacy. I think that if you read the language of the original bill, it was really, I think, much vaguer and didn't didn't sort of capture what I think the case law and I think constitutional provisions would say is what an expectation of privacy is. So I think that makes subsection 1 much better. So for those reasons, I think this bill makes sense. As we said last year, it adds to 255 by providing a greater level of protection. In particular, it has the opt-in provision that says if you are one of the covered third-party providers of information and services and you want to get a consumer like us to consent, it has to be in a specific thing, that a specific request. It can't be, along with a bunch of other stuff, and you have to specifically make an affirmative act of consent. So it can be done online, but it has to be, separate. Are you consenting to this disclosure? And you have to affirmatively say yes. I think it makes a lot of sense, and I hope you'll support it. Anyone else wish to be heard? Yes, Representative McFarland.
Thank you, Mr. Chairman. So I very much appreciate some of the work that's been done in this amendment. I mean, including the item on page 1 that you were alluding to that I think is responsive to some of our prior conversations. I want to be in a position to vote for the amended bill, and I unfortunately still have significant concerns over the amendment as written, and maybe I am missing some facts here. So I'll just throw out a couple of comments on the amendment. The first is with regard to page 2, line 2. It uses the word necessary, and I would suggest that it ought to say something more like appropriate, because there are going to be circumstances where the third-party provider is desirous of using other service providers and vendors and subcontractors, but an argument can be made very cleanly that it is not necessary. And I think that brings me to the next point, which is that in general, I don't see in here any language that permits the third-party provider of information and services to routinely use these other vendors and subcontractors. And I know you made reference to the paragraph E, the information is disclosed in order to provide the services. And I think that one arguably would encompass some subcontractors, but only to the narrow extent that that is aligned with and necessary to provide the service, and is not something that is ancillary to the provision of the service, but nevertheless part of the routine operations of the third party. And so if I'm missing something there, I would be grateful to hear about it. I think the next thing I would bring up is that in line, again, page 2, line 24, 25, the ability to provide information to those government entities is conditioned on the government entities requesting them, but it's not clear how the third party could voluntarily seek to provide information, which again is something that I think is a matter of routine operations, especially for the same kind of reasons as are laid out on lines 1 to 3, without rising to actually reporting a crime or having any reason such as that to come back to them. So if I'm missing some language in here, Mr. Chairman, I would be happy to hear about it.
So I guess what I would respond, I don't think that my inclination from what you said is I don't think you are missing anything, but I think that in other words, just to give you gave the example of, subsection E on page 2 allows the information to be disclosed in order to another, in order to provide the service that the individual has requested. And you suggested, well, what if the business's routine is to disclose information to another business, not necessarily to provide the service, but just because it's kind of ancillary and we've always done that. And I guess my response to that would be, I think, I mean, that is one of the things that this is designed to stop. If you read the exceptions, I think they're designed to say, look, a business should be able to do all of the things and use the personal information of somebody for all of the reasons that I think all of us would say is legitimate. To provide, if the credit card company needs to have my personal information so that when I buy something from Amazon, they can allow me to pay for it. Sure, Amazon should be able to do that. But if it's not for that purpose, if it really is, they don't have to do that. But they do it because for some other reason that's really not reasonably necessary to their business, then that is what this is designed to stop. It's designed to say, look, businesses, if you've got this kind of personal information, fine. It's fine to use it for things that are related to your business or for other reasons when there's a legitimate reason, but not for just, you can't be sort of sloppy with it. And I think that's kind of what this bill is all designed to prevent.
Yeah, and I think, as a privacy advocate, I certainly am amenable to that sentiment in general. In fact, and I didn't make a comment about it, but your comment on page 3 about the language in 8, 9, 10, I mean, frankly, I think that we should be asking these companies only to not disclose when they're receiving, a request that's targeted at an individual's information, when there is, a court order and a requirement to keep it confidential. I'm troubled by the option A on line 9 on page 3. But back to the point on page 2, I think what I'm saying is not about frivolous types of act on the side or acts that are maybe related to marketing or something else that we're trying to stop. But I mean, I guess without thinking through every possible circumstance, if the word necessary in line 2 were said appropriate, I probably could get past that.
Well, does it help you at all that it says has reason to believe that it's necessary? In other words, it's not, I think the test, I assume the test under that would be, did the third party provider act reasonably in thinking it was necessary, as opposed to sort of it absolutely was necessary. I would think that, that does set a standard of reasonableness. Other comments?
Yes.
Yes, Representative Birch.
And again, this is more a question of clarification, which arises a bit from what the representative raised, the question of turning over information to the government, which under whatever section that is, that he was by request. So let's move to, which I think is fairly limited. I mean, if I'm a business and I come across something that I think the government should know,
right,
I hopefully won't have to wait for a request. From
No, that's what B on the top of page 2 is to, B does not, on the top of page 2 is designed to cover the situation where there is no request from the government, where the business is acting on its own initiative because it has reason to believe that there's, that there's something wrong going on.
Right.
Criminal,
So-
fraudulent activity, identity theft, etc.
So using that provision and going over to the next page, when a third-party provider discloses that information, presumably under B, I'm wondering how the two time factors interplay. One on line 15 that says the provider shall promptly provide that notice to the individual. So hold on to the word promptly, unless the government demands that it not be turned over, more or less. So what is the provider supposed to do when he turns it over and the government person says, well, that's interesting and important, we'll get back to you? So does the provider then ignore the promptly and wait for the government to respond in a day, a week, or a month? Or does the provider do promptly? And I don't know how, can you suggest how those two are reconciled?
I'm not quite sure I'm following. So
Does the provider's turned over the stuff? Which comes first, promptly disclosing it or waiting for the government to demand that you don't?
I think promptly, I think B on page 2 is designed. Let me hang on one second. Let me just make sure I've read this correctly. 1, 2, 1.
Yeah, I get the B. Talking about page 3.
Yeah.
Line 15 versus line 18.
15. Okay, so the provider discloses information pursuant to RC 121C. Disclosure should promptly after disclosure.
Which
provide
master does
notice
the
that has made disclosure to the individual?
does the person answer to first?
Shall well, no. I mean, if the provider of information is providing the information not in response to a request,
right,
but in response to its own suspicion that something's wrong, the provider would then, I think the provider would promptly notify the credit card holder or whoever it was. It's the person. I mean, it's the person who has the privacy interest. So disclosing it to that person, I don't.
But suppose it's a computer image of a child, a bad image of a child on a computer, and they notify the government properly that there's something wrong here. The government may well want the company holding the computer not to turn over that information. Hey, we told this to the government.
Right.
But they're under an obligation to promptly tell the imager what we turned over. So which goes first?
Sure. So no, but I mean, wouldn't it, I think the reasonable way to read that would be, would it not, if the company discovers the child image and turns it over to the government, right? Wouldn't I mean, I would presume that that the person turning it over would say to the government, we're going to disclose this to, whoever we have to disclose it to under the statute, unless there's unless you tell us there's a reason not to do that. And presumably I mean, I suppose if they say, if the
they don't
government
get an
entity,
immediate answer,
if the government entity said no, I mean, that,
if they don't get an immediate answer, they turn it over. I mean,
I guess I suppose that's right. If they've asked and the government can't give them an immediate answer, yeah, I think they probably do. Yeah.
I wonder, I don't know if the law school that you went to and the law school that my colleague, Representative Birch, went to used the same technique for teaching law, but whether it is the Socratic method. But my question is this conversation, which is fascinating for all of us,
thank you,
going to make any difference in how anyone votes on this bill? And have we perhaps exhausted the pleasure of an intellectual exchange? And we could move on. And it's not that I'm going to say we pass this bill, it passes the House, and we rely on the Senate to fix it, because I don't ever rely on the Senate to fix it. But I also just wonder if we could move the conversation forward.
No, you are very kind, and I think I suspect that Representative Birch and myself have kind of gotten into the law school debate, I suppose, which everybody wants to fall asleep for. So I have no further comments. Does anybody else have any comments on Amendment 0890H to House Bill 195? If not, I would ask, can we do this by a show of hands on the amendment, or does anybody want a roll call? All right. So seeing no objection to a show of hands, so all those in favor of adopting Amendment 0890H to House Bill 195, please raise your hand. 17, all right. So it appears 17. All right. Amend. Right.
You have to get the other vote.
Yeah, no, I know. Amendment. What is it? 0890H. H. Right, 17-0. All right. So now we're on to the main motion. Ought to pass as amended, and I would move ought to pass as amended. Representative Smith, is there a second?
Seconded, and I called the question.
All right, all right, yes, good, all right. So this will be a roll call on the motion is OTPA on House Bill 195 with Amendment 0890H. Oh, yeah, no, I'm sorry. Yes, I'm ready. Absolutely.
Vice Chairman Mannion,
Yes.
Representative Tripp,
Yes.
Representative Andrus. Yes. Representative Kutab,
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland,
No.
Representative C,
Yes.
Representative Smith, Representative Horrigan,
No.
Representative Birch,
Since we already have a bill that covers this, no.
Representative Harvey,
Yes.
Representative Manos,
No.
Representative Tur,
Yes.
Representative Rombo,
No.
Representative Bergeron,
No.
and Chairman Lynn.
Yes.
11 yeas, 6 nays.
All right. I will write the majority report. Is there going to be a minority report?
It has to be Birch.
Yeah.
Has to be after that.
Yes.
I think someone else may have their hand raised. though.
Well, I will.
What do you recommend?
It doesn't have to be a minority report, but if
No,
anybody,
yeah, I'm certainly interested in putting in a minority opinion. I don't know if it'll be the same minority opinion as Representative Birch's.
all right, all right.
Just so
all
it's
right,
not a
so-
30-page document.
All right. So McFarland will do the minority.
But I'm glad to consult with a good representative.
Minority. All right. All right. We have one bill left, 522, which is a 522 is the companion to 195. So 522. Let me find it, make sure I've got the right one. So, all right, so I'm going to, on 522, I just want to make sure I've got the right one. Yes. So I'm going to recognize myself, and I'm going to move ought to pass on 522 with amendment 2025-0929H. Is there a second? All right. So moved by Lynn, seconded by Smith. Let me find it here. All right. And I would like to speak to the amendment. This bill, as I said before, is the companion of 195. 195 is directed at the third-party providers of information and services. As the same as last year, 195 does not contain a private right of action. It's limited to the Attorney General enforcing it. 522 is directed against the governmental entities that receive private information from third-party providers of information and services, and it says what governmental entities can then do with the information that they get from third-party providers of information and services. And this bill is, the way it is drafted, there are two main operative sections. Section 2, Roman numeral 2, which begins on line 28, states the general broad proposition. Unless specifically authorized by statute, no government entity shall acquire, collect, retain, or use any personal information of an individual residing in New Hampshire from any third-party provider. So you might say, if you read that, well, boy, government entities can't do very much, if anything, with private information. But 3 then sets out what they can do with private information, with information obtained from third-party providers. And if you read through Roman numeral 3, sections A through G, it basically says that governmental entities can use private information obtained from third-party providers for any legitimate purpose. I mean, I'm summing that up, but if you read through it, that's what it says. So that it's the exceptions are very, very broad. And as I think we may have discussed, I don't anticipate, unless government now is keeping information for some that they don't need to have or using for some nefarious purpose, which I believe in New Hampshire is not the case. At least I hope that's not the case in most cases. The operations of government should not change at all if this bill passes. But this bill, unlike 195, this does contain an opportunity for a private right of action against the government or government agents, and would allow. First of all, it makes a knowing violation a misdemeanor, and secondly, it allows for a private right of action to recover either the greater of actual damages or $1,000 for each violation. So, again, I think this makes sense. I don't think it will make any kind of major change in existing law, and to the extent that it stops some government entity from collecting information that it has no real reason to collect, or disclosing it when it has no real reason to disclose it, then I think that's a good thing. So I would move the amendment. Anyone else wish to be heard on it? Seeing none. Oh, I'm sorry. Yes. Oh, okay. All right. So is everybody all right with a show of hands vote on the amendment?
Yes.
So I'd say all those in favor of amendment 0929H, please raise your hand. Oh. 17. All right. Appears that the motion passes 17 to 0. Hang on. All right. So we're now on to the main motion of ought to pass as amended, and I move that. And is there a second, Representative Smith? Thank you. All right. Any further discussion on HB 522 as amended. The motion being ought to pass as amended. Any further discussion? All right, seeing none, ask the clerk to call the roll.
Vice Chairman Mannion,
Yes.
Representative Tripp,
Yes.
Representative Andrews. Yes. Representative Kutab,
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland,
Yes.
Representative C,
Yes.
Representative Smith. Yes. Representative Horrigan,
Yes.
Representative Birch,
Yes.
Representative Harvey,
Yes.
Representative Manos,
Yes.
Representative Tur,
Yes.
Representative Rombo,
Yes.
Representative Bergeron,
Yes.
and Chairman Lynn.
Yes.
17 yeas, 0 nays.
All right, can this go on consent? All right, consent. All right, and I'll write the I'll write the report on this.
Mr. Chair,
Yes.
I would particularly like to thank the substitutes who sat through
Yes.
a very difficult time.
Sure.
And I would also like to ask if we could request that Representative Harvey be assigned to come and sit behind Representative Birch's chair.
Second.
Yes.
It hasn't worked yet.
All right. I think we got through everything we needed to get through. Am I correct on that? I think so. And I think. Oh no, thank you for being here and for your contribution for sure.
You're awesome.
I think we are now done with all the House bills so our next task will be next week to deal with the presentation from the Human Rights Commission, which is very important. And then we will begin getting Senate bills, not too long, and we'll deal with them. So again, we'll have at least a little bit of a break, but thank you all for hanging in there. And I'm sorry we didn't get to the 2:00 presentation, but maybe they're still going on.
Let me just tell you that it will go on probably to 6.
Okay, so I would.
Really want to go, be my guest.
I'm going over. I want
Do we have a leftover question about where the chair went to law school?
Is that a serious? Oh, I went to UConn Law School. I'm a Connecticut native. All right.
Well, at least you both went to law school starting with the letter C.
Pardon? Oh, thank you. You know what? You know what? Can I ask to have the reports by, say, Friday at noontime? Is that reasonable? Friday at noon? Okay, that'd be great. All right. Terrific. All right. All right, great. Thank you, everybody.